Good morning. Good morning. It's a little bit of an early one because we are here for trial day one of Florida versus Sarah Boone. They will be starting with opening statements at some point today, but for you on the replay crew, it'll all be timestamped down below so you can get to what you want to watch most. It is Friday, October 18th. Yesterday, we covered the pretrial motions in the Sarah Boone case. If you are new to this case, she is accused and charged with second-degree murder for the killing of her boyfriend, Jorge Torres. The defense is saying that it was a mistake and or it was in self-defense, and the prosecution is saying absolutely not. She knew that he was in a life-threatening situation. She doubled down and then she left him zipped into a suitcase. And what we heard more about yesterday is that the prosecution has also said that she not only said that she hit him multiple times with a baseball bat, but that his injuries and his autopsy also confirm that he was hit while he was in the suitcase with a baseball bat, which is going to make it very hard for her to run the self-defense that she is hoping to run. This morning's going to start with motions argument. That's where we left off yesterday. The court was finishing up jury selection in Florida on a second-degree murder. There is a 6-person deliberating jury, but this judge has lots of alternates because stuff happens. It's busy. Trials are busy. So today we're going to start with that discovery hearing and the defense turning over stuff late. Yes, these defense attorneys have only been with this case for about 45 days. However, they chose to take this case after Sarah Boone was deemed to represent herself. And when they chose to take this case, they knew the trial date was set. So the judge does not have a lot of empathy. The defense attorneys, though new to this case, are deemed to have known everything that has been known from all the past 8 attorneys and Sarah Boone herself over the past 4 years. So if you are ready for gavel to gavel coverage and don't want to miss a minute, I'm going to plug our app that we built for you. Why? Because I love it. And 2, because we built it. And 3, because I love it. So lawnerdapp.com. And when we do get into opening statements, we will send out an additional bump notification. So if your days get busy and you need a little nudge, like have they finally started opening, I've got you. We're going to just send you notifications. We're going to send notifications. Okay. Are we ready? It's time. It's time for trial, Law Nerds. I love trial with the Law Nerds. I love being here. We're going to roll the intro. I'm going to pull up the court feed and we're going to jump into the beginning of motions argument. You know they're going to take a break before we get to opening statements anyway. So we've got some Zoom room, and the court didn't start till a half hour after they said they were going to start. So the amount of Zoom room we have this morning is massive. Let me know what you are having in the snack. Breakfast, lunch, dinner, snackies. I've got coffee. I've got some questionable bacon and an English muffin this morning. That's what we've got.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the Law Nerds unite to talk about facts, not. Let's get into it.
All right, so things that are going to probably happen in court today. It's going to be hard to hear the defense attorneys. Maybe that'll be better than yesterday. Maybe it won't. At some point, I'm sure my volume will be lower and or higher and or not mixed properly. It is an ongoing issue we are having with our streaming software. Would we change everything? Yes. Can we do that during this trial? No. Are we working on that? Yes. Is that happening this moment? Also no, but we're going to go to court right now and see how it goes because, you know, the streaming is dynamic and it's always an adventure. So let's see. When I say questionable bacon, it's just because my son, Dingoes asked, what do we mean questionable? My son likes it very crispy. So it is so crispy. I'm not sure it counts as cooked bacon vis-a-vis burnt bacon. Oh, that audio is not playing where it is supposed to be. Give me 30 seconds. And then we will be able to hopefully hear that better. I mean, it's just rustling papers, but, you know, Griffin loves his bacon so crisp that I don't know if it counts as crisp. All right, let us zoom till the judge is on the record, but you can see all of her attorneys have the accordion folders, by the way, on their desk. Emily, do we always stop this much? Yes. The accordion folders on their desk were my favorite way to prep for trial. Those accordion folders were my favorite. That is how I prepped for in trial. Yes, I would sometimes have boxes at my feet, but those accordion folders, 10 out of 10 bay, I would color code them for the type of trial. Murder cases for me were always also in red.
Win case of the state.
James Owens on behalf of Sarah Boone.
I can hear you so well, gentlemen. Oh, there are so many people. I've never seen them swear in the defendant to take her name on the record.
I do.
Ever.
Ma'am, good morning. Can you please state your full
It's
name and
unique
date of birth
to
for
me.
the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person, so we will be standing when our jury enters and exits.
This is a coffee first. This is a love your screen name. B, this is an important question. Who are all the people behind the judge? It really generally depends. It could be court administration. It could be clerk staff administration. It could be the judge's research attorneys. It could be the research attorneys in the courthouse, but it is staff members from the courthouse behind the judge. He might explain, he might not. So the judge is talking about what they will and won't be doing. And the judge is just noting that Sarah Boone is who she is for the record. So there's no debate 20 years from now that she was not present in court. It also helps that it's on TV. I mean, you can just roll the tape.
Tony Henderson, Sarah Boone.
So, good morning, everybody. It's good to see you. Don't worry, we'll get a different view of the courtroom
I do.
at some point.
Ma'am, good morning. Can you please
I'm
state
sure.
your full name and date of birth for the
switched
record
yesterday.
for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit
I
and
remembered
a
all of my
pink
lippies
blouse.
today.
She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury
They will be
enters
able to
and
stand today because
exits.
she has no restraints.
Before
That's
we bring in
great.
our jury this morning, yesterday the court had reserved on a Richardson hearing
That's an
regarding
evidence hearing.
Exhibit
Not an evidence
2
hearing, a
as
discovery
identified in the
hearing.
defendant's fifth amended reciprocal discovery exhibit list, specifically 119
Exhibit
pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was
Not
to
a BS
provide an
USB, an
edited
actual
version
USB.
of only the records pertaining to anxiety and the lack thereof,
So this
or
is continuing
anything
on from
pertaining to
yesterday.
those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
I like this judge so much.
Most of them deal with just billings, observations by the medical personnel, so don't necessarily apply to the issue of anxiety, as the court indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related, that may be relevant to the case.
Can you guys see the closed captioning though?
Of those 119 images, how many are being sought? 15? Okay, thank you.
So when he says how many are being sought, he's saying how many are you seeking to put into evidence? You gave 119 pages to the prosecution. How many pages do you want? And he is standing up away from the mic because he's behind counsel table. It'll get better. That's why I wanted to make sure we have closed captioning and that you can see them.
State response.
Thanks, State, for coming to the podium.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank
I
you.
do speak of the
Nor
81
the
pages,
new
Your Honor.
119
You're a delight.
pictures that still not in a PDF form. So of the 15
It's still a
pages,
fucking JPEG,
the
Your
first
Honor.
2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I had to, I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22. 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted.
So they're talking about BAC
0.165
for
grams
everybody.
per deciliter, over twice the legal limit. It's a central nervous system depressant.
Did she drive there?
We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
Thank you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do
not
want
mysterious.
page 48 included. On that page includes her height and weight at the time.
I think that's relevant.
Page 63,
What's 49?
Especially vis-a-vis the victim's height and weight.
So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was
Bless you.
tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48
They're
to be
asking to
included
include
between
48.
47 and 49.
And the judge
to
asked
make
if it
sure
was
it's relevant and complete.
Right.
But they are also seeking 49, correct?
Yes.
Thank you.
Just they just skipped
The judge is like-
48, just like they skipped 26.
Answer
Okay.
what we want.
Page
The shade
63.
already.
It appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that. So basically, we're asking for pages 26 and 48 to be included.
Okay, thank you. The state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was
Again.
unable to provide any specificity. He's going to confer with his
This
office.
happens.
Mr.
defense
Owens
is
or Mr.
scrambling
Beck, are you in a
because they came
position
in
to
so
advise when these documents were first
But that doesn't
requested,
help.
when they were received?
So,
and
Chad,
when they-
we talked about a Richardson hearing yesterday. It looks like it'll be helpful to talk about it again. The judge determines numerous factors with regard to the defense turning over, and it can be to either party, but the defense turned over discovery late. Is that a willful violation? Was it intentional? Was it inadvertent? Is the document relevant, not relevant? How impactful is it, and how prejudicial is it to the prosecution to get it late? So the court's going to go through all of that and try to decide if this was a violation of the discovery rules, and then what the remedy is. The remedy could be keep it out. The remedy could be, whatever the court decides. And part of that is because this defense team came on so late, they are doing defense work that just simply was not done to prepare for trial before, because they weren't part of the case. And Sarah Boone was representing herself and didn't do it. However, she did have an attorney, 8 of them. And so they're stuck with where they're at. Like, you made your bed. The judge said yesterday they parachuted into this case. They volunteered as tribute, and now you're kind of stuck with what you got. So let's see what the judge decides.
They were sent to the state, specifically any documents pertaining to Exhibit 2, the Advent Health Winter Park records.
Judge, I did check with my secretary, Margaret, and my understanding is.
Oh, it's not Margaret's
I
fault.
didn't know that was going to be a question about when we actually sent it out. I know it was.
He asked you that
on my trips down
yesterday.
here, I got Sarah Boone to sign a medical release.
It was the first thing he asked you yesterday, and you said, I'm going to have to check with my secretary. It was one of the first things he said yesterday. Counsel.
We sent it to the hospital. It took a couple of weeks, I want to say.
Ugh.
We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. And I think it was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches?
But you
Because my
had them.
understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time
This
as
is
to
so
when
much
these
not this
items
attorney's
were
first rodeo.
not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from the Advance.
I have no idea who's speaking at the moment. Lawyers have continued to just come out of the woodwork. Laura asked if Richardson and Brady are the same thing. No. Richardson goes to the local rules, and most local rules have something for discovery violations that don't raise to the level of specifically Brady dealing with the prosecution. So they are not the same thing, and I would imagine the remedies are available are not the same. So the defense team keeps embiggening itself. And yes, for all of you, there is a very large, my friends, I get it. I'm also annoyed by the cant of the box in the courtroom. Given the size of the box, I wonder if that was the suitcase that is relevant to this case and whether or not that will be shown in openings. So it's going to sit by the clerk's desk until it can get checked in. So I imagine that's what that is. But that's me speculating. He said we had to pay $135 to get the medical records, and then we got them. Rachel, we can probably make that happen. They thought that state had them.
Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, if I stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the
The people
purposes of
behind
the
the clerk
Richardson
are
hearing
likely
will be
research
received
attorneys,
without objection
judicial
as states
staff.
1.
Emily asked, why is the defense allergic to microphones? I don't know. They parachuted into this case, presumably for their chance at a close-up. If you don't know what that is referencing, go watch the quick bits. I showed her advertisement for the judge or for a
Just
defense
a
attorney.
reference that 81 pages were all marked up by the defense. There's no markings. The issue and
Yeah,
the
the camera
confusion that
angles
the
have
state
changed
attorney's
today.
office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions,
Hey,
due to
Chad.
publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you.
Chad.
You may proceed.
What was
And
the
I
ringtone on
realized
my
that
cell
I've
phone
only
when it
had-
went off in preliminary hearing court when I was a young DA? I know some of you know exactly what ringtone I had on my phone when it blared through the courtroom.
Had a limited amount of time to review the 119 pages that came in yesterday. And again, it's
I see you,
more
Chad.
difficult to review those
Get
because
'em,
it's
Warners.
not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68,
Yes.
Some of you have amazing
And referring to
suggestions,
68
though.
of the 81 that was
Yes, sir.
entered as 1, correct?
yes, sir, it is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a
Your Honor, it's a fucking JPEG. I can't put it anywhere. It's not going in Notebook LM. I can't OCR it. I can't word search it. They gave me a JPEG. So I have to go through it line by motherfucking line, Your Honor. Because they didn't do my work or because they didn't do their work, I can't
119-page
do
PDF and you make it word
mine.
searchable, you just put in the magic word and it helps the attorney greatly.
But they gave me a
So
fucking JPEG.
that's why there's this confusion, and that's part of why I had to raise this issue was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again. And I'll
This is
provide.
all because
I appreciate y'all
of
working
timing.
together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed. So we were there at
What?
8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay, appreciate it. All right. Any other argument with regard to the Richardson issue?
They need to photocopy?
Anything further, Mr. Beck?
Not
Okay.
only did these attorneys just come onto the case, but these attorneys are from further north in Florida, so they are also not within their jurisdiction. So I get it. They are completely discombobulated. However, no one made you do this. You chose this.
With regard to, let me conclude the Richardson analysis first. All right, thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court
These are the
finds that
prongs.
based on the
I think
positions
it was
provided by the
inadvertent.
defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to
So now we're
pages,
shifting into the
26 and
403.
49 as,
So now he's shifting, and he has said, look, they should have turned it over. It was inadvertent. The judge knows the defense team is scrambling because of how late they came through here, but he knows that. So he's giving a little bit of grace there, being like, it was y'all thought you had turned over everything in those previous disclosures, and then it was different, on and on. But he did find that because they complied and narrowed it down and turned it over, that it can essentially be fixed. And it's early enough in the stage of trial, it's not going to be the worst thing ever. This is not the worst violation we've seen. Anyone that's keeping up with the YSL case knows that we are far afield from the worst discovery shit we've seen. Ask Carrie Morrissey in New Mexico. So the judge is giving a little leeway there, and now moving into, okay, but you wanted to pull out a couple pages, and now he's going through, do those pages come in or stay out?
26 and
That's
48
the 403.
as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted.
Michaela, you can
Pages
convert
26 and
JPEGs to PDF easily, depending on what you have access to and depending on the quality of the JPEGs. You'd be amazed at what is unavailable on government computers, and putting any evidence from a case on a personal computer can open that personal computer up to appellate review down the road. So the prosecution is fairly limited by what they're allowed to use on their state's computers. And sometimes I didn't even have at one point, a program where I could combine PDFs. So if I had like every page in a separate PDF, I had no way on my work computer to combine them into one. And if I ever used a personal computer, then it could be subject to search for using personal stuff. So that's part of the problem here. And also, it's like not their job to have to fix it, and they generally run, the lawyers are doing most things themselves, if that helps.
48 will be included in any evidentiary documents that sought
Okay, so
to
the
be
pages are going in.
moved into evidence with regard to this January 23, 2018 incident, as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they're able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening
They should
statement.
show those.
The ones that I've seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that
May not
could be
this
coming
one.
into evidence. I identified at least
They were
one that I
supposed to do
don't
this
recognize as
yesterday.
something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they
So you're
are
not
seeking
playing the
to
video?
do, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in.
Judge didn't rule that.
That it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the
Passive
defendant's
shaming, it's
past
good to see you.
injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
This was supposed to happen yesterday.
Judge, yeah, the defense is self-defense. Sarah's going to testify that
Shit back in the
she
horse.
was defending herself. We believe the court's going to rule we're entitled to put on a case
Bold
involving
strategy.
self-defense. And under the instruction for justifiable use of
I don't necessarily agree with you, counsel. Bold.
non-deadly force and the justifiable use of deadly force.
I'm not discussing the jury instructions.
I'm also hoping the camera angle will switch as we get further on like it was yesterday, but we'll see.
This time.
There are evidence of prior threats, of prior events of violence.
How the fuck can we still not hear him even when he steps up to the podium? What is happening? What is that? When the prosecutor steps up to the podium, glorious. He steps up to the podium, can't hear anything. I don't even understand Owens.
Here's my concern. Why are we addressing law in opening statement?
Bing, bing.
I agree with the state attorney. I did.
Then why is it in your opening?
A couple of these on the justifiable use of non-deadly force.
It still, that does not answer my question.
I would do not to use them.
Okay?
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense and decide which is the best evidence.
They're arguing over whether you can use jury instructions in opening. This can vary widely by jurisdiction. However, there are standard instructions that are given in every case. I think I have only ever seen anyone use the standard instructions, like the state has the burden and you judge the evidence for yourself and all those sorts of things. But when it comes to specific instructions, like an instruction for self-defense, those things can be modified, they can be given, they can be not given. The argument over jury instructions is a critical and important phase of trial, and we've seen that have huge impact depending on the case. So he has blow-ups of demonstratives of jury instructions that may not be given. And again, you can't put the shit back in the horse. You can't unring the bell. If you're letting the jury hear those instructions, it might always be in their mind, where's this going? When you're talking about the standard instructions or even the opening instructions, the jury gets instruction on the burden of proof before and or immediately after opening statements. Those standard instructions that are given in any case are generally fair. But when you get to the end of it, no. For those of you asking, Murder Mittens, love the handle. Yes, he was an elected public defender, like the boss public defender in another county. So Yeah, he's done a lot of criminal trials. I just don't know what's happening here.
And which evidence should not be relied upon considering.
So this, what he's reading now is a standard instruction.
No, I can see it, sir.
And then the other one is the reasonable doubt is not in there. Possible doubt, speculative, imaginary, or forced doubt is the standard instruction on reasonable.
Doubts?
What's your position with regard to those two,
Doubts
Mr. J?
fine.
Judge's opening statements, we should be discussing what we anticipate to come into the
And not
trial,
arguing law. I
And
mean-
that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions.
And the court does get
Which we
that.
have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years.
That doesn't mean you've been doing it right.
I've used these boards at opening statements I don't know how many times.
Sorry for the
I've said
snark.
that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And
It's a
then
standard
this weighing
instruction.
the evidence is a standard jury instruction that applies in every case.
Yeah, I think doubt is
Are those the
absolutely fair.
standard? Is that the language of the standard instruction?
It's got to be
I
identical.
have not had the opportunity this morning to pull up
got to be
Florida
identical.
Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions in limine, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete, just from memory.
He always finds a way to be like, Your Honor, I have other shit to do, but defense fuckery is fucking up my time. However, I have empathy for these lawyers. Trial is exhausting. They have been living with this case for 4 years, the prosecution, and they are tired.
And I know that's not the complete weighing the evidence instruction either.
That's a
It's an
problem.
entire page
That's a problem.
of instructions for each of those.
Can I see the reasonable doubt instruction, please?
Yeah, now we're going to have to check and make sure they match.
Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not.
Fuck. He said the Supreme Court of the state revised that standard jury instruction earlier in the year. Boom, roasted.
The appropriate definition of reasonable doubt. It is not what was read to the jury during.
This man is going to look at his research attorneys, if his research attorneys did this, and lose his fucking mind.
Well, here's the first problem. That's the wrong instruction.
Judge.
Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection.
Oh boy.
3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or, if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone, the arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from when
The judge is pulling up the jury instructions because now he's like, here's the problem with this. Accidents happen, mistakes happen, lawyers make errors, but you are losing the judge's trust. And the judge is like, I now have to double check everything you do because you're not coming correct. And it's thing after thing after thing after thing. This would make my brain hurt, by the way, with the dyslexia, having to go like, does this line match that line? Ugh. It would make my brain crazy.
Seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which.
Chad, I'm going to put up a poll right when we start opening statements of how, if you think there will be objections in opening to the defense's opening, will they start arguing?
Out of the optional
Don't worry, I'll put it
instructions,
up in a
6
minute.
and 10, we're going to use in this case
In a
because we have
minute.
not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
I need to know why this is the second trial where there's been a can of prime just like placed somewhere in the courtroom. It is becoming a thing.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, you know, that
Yeah, they get pre-instructions.
in many ways, we do it where we give them the law at the very end, you know, and
Pre-instructions.
I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
And I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct?
He wants them
Okay,
marked
so let's
so
approach
that
with
the
that first
appellate
photograph,
record
please. Madam Clerk,
knows
yes.
what they're talking about during this period. All right, I'm going to zoom as we get into discussion of blowups of photographs they want to talk about. That's a small courtroom for that many enlargements. It's zoom time. It's my favorite time of trial is when we get to time travel past all of the awkward sitting there and see how quickly we can get past all of those being marked. Ooh, not quickly at all, by the way. Oh, God.
Next photo.
I can't hear him at all.
Identified is A, Defendant's Exhibit A, purposes of a demonstrative aid in opening statement. It's a picture of Sarah Boone that was taken by law enforcement on one of the incidents involving arrest.
He said it was taken by law enforcement when she was arrested, but I'm not sure when in time. The sound on this is going to be terrible.
Okay. Next photo.
All right, I can't hear the defense at all. He's going to describe these photos. I'm going to zoom to the judge's ruling on this or till a little bit better discussion of this so we can hear.
And Sarah Boone's phone. The state took custody of the phone. The state had the photographs. The state provided.
So he's saying these photographs are from Sarah's phone. So the state has them.
We intend on introducing these photographs. We don't intend on introducing the blow-ups.
Mia, there is a pool camera in court with pool audio. The lawyers are just not standing near the mics. And though there are some other feeds that are boosted a little bit, they don't have closed captioning. And I have opted for closed captioning over the slight boost. So these are the pool cameras. and the pool audio. And this is the feed with closed captioning. So he's saying these are from the phone. I'm zooming because I can't hear him at all.
And enough demonstrative aid.
There we
preventing
go.
states use.
Now we're getting to the
Alcohol
legal
use
argument
and opening.
of whether he's allowed to use a demonstrative, and we can listen to that part.
I'm familiar with the case law. I did receive the email.
Perfect.
I'm not sure if it indicated who all was copied on it, a separate one, but I'll check.
So for all of you that are like, the pool audio, this is not them. The lawyers are standing in the well where the microphones are pointed towards counsel table.
And provided Alsaguer v. State,
They can't
326
boom the whole
3rd,
courtroom.
656, Florida Supreme Court 2021, Lowe v. State 259, 7th 3rd 23, Florida Supreme Court 2018.
Or
Yes,
if
sir.
I have the audio boosted,
Judge, the court has discretion to allow.
but when they're not at the microphones, it just boosts static because now the microphones are pointed at counsel table and the podium. If they are in the well, you just won't be able to hear. They can hear in the courtroom. We just won't be able to hear. That's all we can do.
Demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements.
Hopefully you
In
can't
the,
hear my typing too much.
Alsaguer case, which is the 2021 case. Supreme Court, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin and a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact.
You guys are like, there's an echo. That is strange. Hold on, let me refresh real quick. That is strange that there is an echo because I cannot hear it on my end. So give me one moment to refresh this, which means we might lose where he's at. Apologies, y'all.
Remaining from the one.
I'm going to have to back up because they are arguing that motion before we get to openings, which is what I want to get to. Chat, how about, let me get to where the judge, or if I can see where the judge makes his ruling, and then we'll just get to openings. I'm going to skip their argument. If we need to circle back later, we'll circle back later. Let's see. I'm going to try to find where the judge is finishing this out because I would rather get to opening, honestly. Let's try to do it. All right.
Those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established. And that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent which resulted in an imminent threat of great bodily harm or
And he's
death.
arguing that's why these
And
demands
we
should
have had
not
that
come in.
mitigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming
Remember,
into
it's
evidence.
not argument.
And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition.
Promises.
So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may
But
or may not be
images.
coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, and certainly A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue
Interesting.
a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F,
Sound
G,
got better.
H,
Or at least on mine, it
I.
sounds better.
State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things.
However.
If we meet the threshold.
We knew there was a however.
For this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C,
It was C through I included?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence.
You guys, thank you for
I don't
the
know.
gift of membership.
It wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs.
Welcome, new members.
But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as
If
much
they've
as you
come
want.
in.
But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting.
I have to pause for a minute because the closed captioning said motion in lemonade. The closed captioning is a lawnard. I'm just saying, closed captioning is a lawnard. They also said motion in lemonade. I don't know if you saw it. I saw it. We're here now. We live here now. The motion in lemonade. Thank you for being with us, closed captioning.
It to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open.
That's not what he said.
No, what I ruled
That's not
was
what he
that you were
said at
able
all.
to discuss them.
Yep.
You address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense.
Your Honor, you said we could do it. He said, no. I said you could talk about it. I didn't say you could bring in pictures that may or may not come in. That's an entirely different kitty. It's just a cat of a different color. I love this judge.
These exhibits come in under self-defense. And arguing these, I've said nothing about that.
Well, this is not argument. This is opening statements.
I understand.
It's a statement of what the evidence might show.
Prior acts of violence.
The evidence might not show that.
Standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there's going to be evidence of an overt act.
Okay, you believe there will be,
That she was facing imminent threat, and she reacted.
but that's not.
Understood. Your response to Exhibit B.
That's not how the court feels.
It's her on the back porch with the 2 dogs.
Judge, not only did he abuse, Jorge Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
Ooh.
I believe it is part of the exhibit list. We got this from the state.
This is why they went over the exhibit list yesterday.
They sent over.
Because they didn't want to be doing this while the jury was waiting. And they're doing this while the jury is waiting.
They listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, Jorge Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Okay, thank you.
They're checking, Judge,
All right.
on whether they have
The court's prepared to rule at this point in time. Thank you both for your
The court's like, yeah,
presentations
thanks,
and
don't
your
care.
argument. The court's had the opportunity
Moving on.
to what was pre-marked as A through I
Yeah, those
inclusive.
I don't think are coming
First,
out.
with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law
Yeet.
or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about, this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim
The framing
at or
on
about
this,
the
by
time
the
of
way,
the
from
incident
the
that
cameraman,
reasonably indicated a
10-10.
need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to
But it doesn't
establish.
come in
But the
until-
concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons,
Right.
for your utilization of them in opening statements.
Right.
Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right, are we prepared to bring in our jury at this time?
Bring the jury. Bring the
They've been
jury.
waiting for an hour and 20 minutes, Counselor.
Bring the jury.
We
Bring the
intend
jury.
to play the
Bring the
2-minute
jury.
Suitcase video to the jury in opening statement.
What?
State?
Okay.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during the opening statement.
What's the other issue, sir?
I need to approach eventually.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. I'm not going to allow your photographs, I'm not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to
So
show.
they're not gonna show the
But the
video in
actual
opening?
evidence is going to have to be presented here through witnesses or through demonstration.
Okay.
And publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please,
Get
I would
the
appreciate
shit
it.
out of
Thank you.
here. The prosecution is so ready. They have out of town witnesses that they are very anxious to get to, which means they need to get to opening statements ASAP. So they are very anxious to get started with openings, which they will be doing shortly. But the defense,
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yeah.
jury's
Can the
in.
parties approach for a moment?
The defense wanted to play the video, which is interesting. But it looks like we are going to be getting to opening statements without the attorneys
Members of our jury, good morning.
without the attorneys even getting a bathroom break. The judge was like, they have been waiting for an hour and 45 minutes. What the fuck we're going to do now is opening statements.
All right, members of our jury, good morning.
Jury's in.
I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places,
Right, I feel
things,
like
or
we should
charge
swoop.
involved
The
in this
jury is
case.
in, and we're gonna
That you
get
have
to
not conducted
openings.
any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3
that's
from
what they
my left,
approached
first
about.
row. Yes, ma'am. Okay, thank you. Can you don't approach for a moment?
That's what they approached about. Generally, it is up to the attorney
And a
to
juror
get out.
in seat 4, left to right, first row. Yes,
the
sir. Who did
elevator.
you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
It is generally on the attorney to get out of the elevator if the jurors get in. That is up.
Week, that's the one thing.
Owens should have gotten
All
out
right,
of the
thank you both for
elevator.
your honesty. I appreciate that. Something we talked about earlier this week. That's the one thing that we required and asked of you is just be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw
anyone
or
say
observed that
anything?
would impacted you or influenced you in any way? To have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening.
And that's how picky the rules are. It really is not just an appearance of impropriety, but there can be a lot of things that can happen in an elevator. You just get out of the elevator. If you get into an elevator with jurors on your case, you get out of the elevator. So the judge asked the jurors, did anything you see in the elevator change your mind? They're all like, no. They probably all just stood there silently. Best practice, get out of the elevator. Best practice is if the jurors say good morning, you don't even say good morning back. So the rules are very specific. We are getting to opening statements. The judge is probably going to give some jury instructions before that. I'm going to swoop again because I didn't anticipate there would be moments before we got to opening, and we're going to get to opening. I'm going to put up a poll in just a second about whether or not the defense attorney is going to ring some objections during opening, but maybe I'll just ask in general, will there be objections during opening? Let's get to opening statements, y'all. It's my favorite part of the case. Remember, opening statements are not argument. They are statements. It is the retelling of what the attorney thinks the evidence will show. It is not argument. There is an art to it. To make opening statements compelling without stepping over the line into argument is an art form. When it is done well, it is magical. When it is done badly, you want to scratch your eyes out like you are sitting in a lecture on a subject you hate with somebody whose voice you can't stand. Good opening statements give the jury an overview. I talk about trial being like a puzzle. This should show them the picture on the box of the puzzle. This is what we're going to get to at the end, and we're going to give you a bunch of different pieces. But at the end, it should look like this. It should give them a guide to what the evidence will show. So let us get to opening. It's my favorite.
Statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide.
I love
but remember,
opening
these are not
statements.
evidence.
Except
this
when
is
they're
just
bad, then I
the
wanna
party's
die.
belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you.
All right, Mr. J. If this is like what we saw yesterday.
This case is going to show you.
God fucking damn it, Mr. J. Mr. J? You've made me blaspheme early. He just put that podium to the side and walked immediately away from the fucking microphone. Mr. J, what are you, bro? Go back. What are you doing? Immediately no. Immediately no. Closed captioning. We love you, boo-boo. Fuck. I can't believe he just walked away.
through witnesses. With that, Mr. J, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 POs, that the defendant herself took of this event. The evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. And out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45
Thanks for
seconds.
getting back to the podium, man.
On February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah.
This is what he did
For
yesterday.
everything you've done to me. Sarah. Fuck you. And then the defendant laughs. Sarah. Fuck you. And the defendant laughs. Sarah. Stupid. Sarah. That's my name. Don't wear it out. Sarah. I can't fucking breathe, baby. Seriously. Yeah. That's what you do when you choke me. Sarah. 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 The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words.
He modified it.
And I would submit
Good.
the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you.
It might be more chilling
I
hearing
can't
him
fucking
read it
breathe, Sarah.
before they see it.
You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres
Sir,
is put into this
go back to the mic.
left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she
He's wandering.
doesn't see George anywhere, just Torres, and eventually realizes, oh my God, he's in the suitcase.
He said she realizes, oh my God, he's still in the suitcase.
After taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement. And tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out, gurgling. Then the next thing she does is she doesn't call 911. She calls Brian Boone. Now, who's Brian Boone? Well, Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, they'll co-parent. And that weekend included Friday, Saturday, Sunday. So it's that 3 schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday. And now he's led into Monday, 2020. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that.
This is why some courts put microphones where the jury is pointing it.
You can see in the phone record, he calls her, and then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over.
He's going through,
It's a short drive.
he's wandered away from the mic, but he is going through, and I'm going to try to talk quietly in case you've gained up your headphones. He is going through the next morning with her talking to her ex, the father of her child, and then calling him to come over before she calls 911. So it's all of this stuff going on before she calls 911.
And as she's explaining to him what the heck is going on, he peeks into the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check, please. You need to call 911. He doesn't put set foot.
He said Brian Boone saw that there were, I think he said blue legs, like clearly not someone who's not okay, legs sticking out. And that's when Brian Boone was like, get me out of this house.
Into that townhouse. He does wait outside, though.
So he goes outside.
So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call.
And then she calls 911. So the amount of time she waited to call, they will probably argue later.
What you will
goes
not
to,
hear
yay,
are tears.
goes to how concerned she was. And if they argue accident, it'll go to how concerned. So I think that's what he's going to get into now.
You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR.
Oof.
He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible.
from the
This is
911
horrific
call?
what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office in autopsy. What the doctor found was
This is the autopsy.
suspect after being left in a suitcase, probably about in the fetal position. He passed from positional asphyxiation, meaning like you're not
So what he said is the victim, Jorge Torres, was in the suitcase in the fetal position, which is probably how he fit. I imagine that's what that big box is in court, is the suitcase, that he was in the fetal position and he died from positional asphyxiation. So the inability to breathe due to the position.
crumpled up like an organ, and environmental suffocation.
And environmental suffocation.
Plastic bag
Zipped.
over your head,
Suitcase.
tape shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, he suffered from blunt force trauma on his torso and his face.
And he also has blunt force trauma on his torso and face.
Contusion will help her explain contusions and bruises. She'll use words like hematomas. Will help her understand for you all that that means bleeding under the skin.
He's talking about the coroner.
Expecting to bruise, that's why they're running you. But he had all this additional trauma. He had trauma on his fingers as well.
And trauma on his fingers as well.
The sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body-worn camera. And it's more of the same of what we heard on the 911 call.
So they'll play the body worn camera.
Hide and seek. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found at a suitcase by Mr. Torres and giving it to one of their digital forensic examiners. who
They took the phone.
later in the trial.
It was near the suitcase.
But it's time to give
Looked at the phone.
the first interview with the defendant.
Interviewed defendant.
Do the first interview with the defendant in one of their unmarked detective patrol cars there on the scene.
Yay.
And the basics of this remain the same, but there's a little more.
He's only going back to the podium when he's reading the transcripts, which, again, he wants to be closer up to the jury. It's very hard for us. I will try to keep my voice low for those of you that gain this up in your headphones as he's talking. So
Elaboration as you would
I know you
expect
can't all
from
read
trained
the
detectives.
closed
versus
captioning while
getting the
you're
911
listening
call
to
taken.
trial.
But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full, so the description she is saying is one bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same.
Facts.
Many of us may envision
Oh, were these like the magnums?
restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendants.
Sir, was it a mega pint of wine? Sir, was it a mega pint of wine?
Trash can were 1.5 liters. So the equivalent of 2 standard bottles of wine.
It was a mega pint of wine.
A 1.5 liter bottle of wine is 50 ounces.
Magnum.
Given that a standard serving of wine is 5 ounces, you can begin to do the math. And here's
I
receipts.
can't. Don't
The
assume.
day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those two bottles of wine were
Consistent.
recovered. They're going to be produced to you in evidence, and you will see that they are in fact Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had one bottle of wine and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's two 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever.
And then they weren't.
And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art,
I mean,
playing with the
having some
dogs,
wine,
dancing with the dogs.
having some wine, doing puzzles and painting sounds like a lovely evening. How it turns so fast and so bad is going to be interesting to see in this trial.
Playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. Two little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine but were not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drank, smoked, did art, listened to music, played with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean the Orange County Sheriff's Office in part, is going to her phone.
Sorry, you're so close.
That's when they discovered the two videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself.
What?
Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over, and that's where it was. Guys, this is killing me right now.
How is he going to get out if you flip
That's
him
why
over?
I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there.
Where?
When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase.
But you did.
Why is all this going on? It's the drinking. That's what it is.
These are her statements.
It's the drinking.
In the interview.
I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. Though she described it happening before. I'll never drink alcohol again.
I mean, I guess that's true.
She insists that she has no injuries on her. And you don't have to take her word for it, because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words.
Yes, I'm restraining the urge not to sing. Today was a good day.
What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is,
What?
hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh.
Boy.
Torres. Referring to Mr. Torres. Getting rid of.
That's what the case is. Yep, that's the case.
That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. It is a door we shall not enter without permission and invitation. Halloween is in like 13 days. Part of the vampire lore is vampires can't come get you in your house.
Wait. They're talking about vampire lore and the fact that vampires can't come in your house unless invited. I don't know how we got there because the mic is so quiet, but I wore my Twilight shirt yesterday, sir. I did not know I needed to bust it out for opening statements because we were going to be talking about vampire lore. What?
During this trial, we're going to be invited in to the defendant's past relationship for the previous couple of years.
What is happening? Vampires.
And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony to be. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 3.42 once when he got treated.
He said, I think you might hear that the victim, Mr. Torres, is an alcoholic, and I think you might hear that his high score is a 0.34 at one point when he was receiving medical treatment.
This is a man who has serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date, it's another thing to end a 25-year marriage. Despite that first date, there's a second and a third.
He's
Now,
talking
these
about
dates are
early in their relationship.
But, and it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview.
He's talking about prior violence between the victim and the defendant,
Bloody ear,
with the defendant being injured by the victim,
in the leg,
including a stab wound to the leg and black eyes.
lying around in that way. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit,
He's saying we'll be going through their past relationship at some point.
but I'm asking you to not rush to judgment until you hear all
He asks the jury to wait until all the evidence comes in and then decide.
Like a home inspector,
Now we're on a home inspector analogy.
experts to come in and kind of help walk everybody through
We'll have experts walk you through the case
the defendant and the victim's past relationship.
and their past relationship.
Suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized, the experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called
And now he's talking about battered spouse in the DSM.
Diagnostic Statistical Manual, version 5, and I think it's text revision or something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it needs these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts, because it's kind of like grandma's recipe handed down from generation to
He's now talking about mom's spaghetti. I'm sorry, grandma's recipes, and that
But I expect you'll
the DSM is like a recipe book with ingredients to diagnoses.
have experience in
But this is all to get to the fact that
that are violent.
battered spouse is not in the DSM.
The control that can be exerted over on an intimate partner by the other one. Isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You will hear about all this. And what it ties into at the end of the day, after we talked about this during the instruction, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do.
He's talking about self-defense being based on what an objective and reasonable person would do, not necessarily what the defendant thought or would do.
The question would be, well, why wouldn't you leave? In battered spouse syndrome, the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, the isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction requirement. That's what it's used for. It's not used for explaining the subjective.
He's talking about self-defense again, and that the standard is what an objective, reasonable person would do, not
Just like any
what the defendant
or any
was thinking.
home inspector. If a home inspector
Back to the home inspector.
was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. It's highly rated at $600,000. You're not going to take that home inspector's report unless they lift the hood, kick the tires, do all the things that the Fox. I'm here.
He's comparing the experts in the case to a home inspector,
Expert
and then talked about them kicking the tires.
information. An expert's opinion is only
So.
what is the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving the story, even if it's the patient.
And then he's saying the opinion's only as good as the information input.
You gotta find proper information, you gotta check reliability. Particularly, in circumstances that
wondered.
Another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that Ascot syndrome applies. Some people can go home and fight like cats and dogs. And that's just their day, and they get over it. They live their life and fight another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say that it applies to this group. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth to the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears.
He's talking to them about the video.
The state admits that you're going to return a guilty verdict for second-degree murder.
And that after you review the evidence, including the video,
Is that the
you will
defendant
return a guilty verdict on second-degree murder.
Torres, because she decided he deserved it. Not because
He's saying that's because she decided he deserved it.
a reasonable person in her circumstances. Thank you.
And that's the end of the
Thank you, Mr. J.
prosecution's
Any
opening.
opening remarks by the defense?
The reason the
Judge,
court...
we invoke the rule that has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked.
The reason the court asked, and hopefully the defense stays at the podium, but the reason the court asked the defense is because the defense has the right to reserve their opening till the end of the people's case. So they can give an opening now or not. The audio was very tough when the prosecutor wandered away from the podium to get closer to the jury. I'm sure the jury could hear him just fine, but his opening statement overall was reading the transcripts and saying, this case is coming from the horse's mouth. Look at the video. And that was really the heart of it in the middle of all of those mixed analogies. And then him saying something like, if you hear about violent nonsense between them, that doesn't mean that the self-defense is valid here. So there's that. We're going to get into the defense opening if they don't reserve it, and then into witnesses, but the defense does have the right to reserve. That's why the court asked if there are opening remarks from the defense, and the defense said, we want to make sure that all witnesses are excluded from the courtroom before they get started.
Thank you.
And now to the defense's opening remarks.
You may proceed, sir.
Did he just go put his notes on the jury bar? Where did you go?
I was introduced before. My name is James Owens, and I represent Sarah Boone,
Oi.
along with Tony Henderson and Kevin Devin. Now, this is going to be a several-day trial. Obviously, today.
He said this is going to be a several-day trial. And yes, I know there are some different feeds. We are trying to keep a feed with closed captioning. I'm going to try to gain up the feed on my end without causing echo. If it does start to echo, chat, you have to let me know, because I can only gain it up so much. But once we get into witnesses, it will be better. Because all I can hear is typing.
Arrangements for witnesses to find you. Expert witnesses to find you. And we'll know more probably within the day and Monday, so we can plan. But I know your focus is on this case because you took a note to do so.
He said, I know your focus is on this case because you took an oath to do so. This is awful. Hold on. We might have to sacrifice closed caption to have some sound, just for the defense's opening statement, and then come back. Give me one moment. Let me see if I can find any better option for opening real quick. Because the not being able to hear at all is not going to work for me. So give me one moment, chat, and I will see what we can do with regard to the defense opening statement, and if this is any better anywhere. Hold on. This feed is not the full opening statement. Well, that's difficult. Give me 1 second. Let me see if that Miguelina says the audio will get better. Hang in there. Okay. Well, that's the benefit of being behind on time, is that we know. So I'll try to narrate until he gets back closer to the podium. All right. He is saying she was justified in using force. He said, we're going to ask you at the end of the case to find Sarah Boone not guilty because she's justified in her use of force. That her actions were reasonable under the circumstances.
Between Sarah Boone and George Torres.
Oh, hallelujah. Literally keep reading. It's like they turned something else on.
And George Torres were down and out, as you can be. Their life centered around alcohol.
It's like all of a sudden they turned on all the other audio. Okay. Good.
Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years.
Those statements go to his
and there
defense.
were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. And considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances.
So he's saying the force was reasonable under the circumstances. I think it's going to be
And the
hard
most important
with
thing I can tell you
that,
today
though.
is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes,
Keep an open mind, listen to
and come
everything.
to a conclusion. Now let's talk about this day, February 23rd of 2020.
Yes, let's talk about the
The
day.
date of this event. This case has been pending for some time. Here we are, October of 2024.
Yeah.
I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix,
Of them buying wine?
from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex.
It's like, I believe that's where they
Took
live.
their car, they drove over
You
there.
can tell he hasn't had the case
You're
very
going to
long.
see a videotape from Publix of them both going in the store about noon, and they come out with one of those larger bottles of the wine, and then, of course, there's a receipt, and the bottles are in the garbage can. Of course, there obviously is an attraction between the two people. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are disagreements resolved?
Not by
But
zipping
George
somebody
was
into a
very
suit.
jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her.
I mean, that's physical violence too, though.
They bought the wine. It's a simple life. They don't have much money. But they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be a Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then they'll keep that bottle will be in the garbage can along with the other bottle.
We've heard about the bottles in the trash.
Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication. So, Sarah's concerned. Attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle. Well, she drinks as well. And at some point, they're intoxicated.
This just isn't
At a
what she
high
tells the
level.
police, though. She doesn't say she's afraid he's going to get drunk and violent. She says she thinks they're going to drink, have a good night, have sex, and go to bed.
They get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in it. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they hold it back and forth. Well, she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there and, they see each other, they smile and laugh, and she zips him up. And she zips him up and they laugh for a
I
while.
wonder how he's going to talk about this.
And
Because he's not laughing on the video.
they carry on, she sits on the couch, and at some point he says, I can't breathe. Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know, they're intoxicated, she doesn't know whether he's just saying that to try to get her to get him out, or what.
He's basing this off of what she will testify to,
But
but
he's a captive audience.
he should be saying the evidence will show. Because right now he's just arguing.
Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100.
That's all.
But she's got him down. He claims he can't get out. He has to sit and listen.
He has to sit
It's
and
a
listen.
unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long.
It's a unique form
She
of
videotapes
restraint.
it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, the suitcase is flipped upside down. The zippers are on.
Right. So how is he going to get out?
11
It's
minutes
upside
later,
down.
Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes.
I think it was upside down
That is the key to this case.
at the end.
Sarah Boone will take the stand. She will explain what happened. She will explain
She will
why
take
it
the
happened.
stand.
The evidence will show that she was justified in the action she took to prevent an attack from George Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense.
When an attack is imminent.
You can hear from the medical examiner. She is going to tell you about some bruising
We're going to talk about that.
on George Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain. But there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving the back.
Oh, we are going to talk about
Her
it.
son comes and stays with them from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah
What
loves
was
him.
that though?
You know, you're gonna hear why women don't do it. Why women don't do it. And you're gonna hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill. Prosecutor mentioned she wanted him to die. Farthest from the truth. She loved her man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak.
He should have started with, she loved the man, she hated the abuse.
You're going to hear it all. You've got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. Thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And where her son is at, Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls,
Sir,
Brian, look, what do I do? He said, I'm coming over.
you call
Please,
911 when
come
someone's
on.
purple.
He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute, 2. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking. And
If her body
somehow
language is not
responsible.
freaking out, it's going to be difficult. I don't think that's what it shows.
Eventually, she gives a statement to law enforcement. She gives one to Detective, or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And you know, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to
That's
They
not the
have
next
a
day,
phone-
but-
Phone extraction people at the sheriff's department, where they can take it,
I think he got.
they got all the data, all your phone calls, text messages, photographs, videos, all that. And they found these two videos. Sarah's not aware, she doesn't remember making the video. You can imagine.
I mean, that's what the prosecutor said.
Gives them the phone,
The facts are the
and
facts.
she makes no attempts to do anything other than, here's the phone. So they tell her, you're gonna get your phone back tomorrow, we'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson is her name, Chelsea Hobson. And they end up, Deputy Hobson was pregnant, or Detective Hobson was pregnant, said, end up, hey, we're not gonna bring your phone, I'm not feeling good, pregnant, can you come to the sheriff's department? Which Sarah Ben was telling you, that was what I was going, that's what they told me, I was going to the sheriff's department.
That's not the serve you
Well,
think it
instead,
is.
it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, you got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audiotaped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not.
Ooh.
So she lies.
He said this was not intentional, but if it's
She's not a
self-defense,
lawyer.
it's intentional.
She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's
That's-
justified in using the force that she used.
Might be a problem.
She doesn't. I wasn't there to advise her. No lawyer was there.
This is a problem.
So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you.
Prosecutor can't take notes on this fast enough.
And we
Neither can I.
simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone gave. So you're going to have to weigh that
I need to go back and
in her
look at some of
testimony.
this. He was saying she didn't know she could justify the use
Now,
of force.
self-defense, we talked about it in jury selection.
I need to go
Using a
back
gun,
and look at
some
how
deadly
he
weapon.
worded that. That is going to
The
come back.
suitcase in this case was a physical restraint or a blocking of an attack. But it was unconventional.
So that's,
Self-defense nonetheless.
but that's intentional. You just said it wasn't intentional.
Now, as I said, the
You also
struggles
said
that
they were
occurred,
laughing when he got in it
many of
and
them
joking.
involved police.
So what attack is she
So you're going to
blocking?
actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there.
I can also
So
be
her
more
attitude
critical of his because
is
I
not
can
a
hear
one of
him.
restraint.
He's been contradictory within his statement.
We're here today, full, packed courtroom.
And?
Judge Craven's here, but you're the most important people. Because you've got to decide this case
That's true.
honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is
when you
brought
don't have a
into a
defense,
courtroom
argue the
and accused of a
Constitution.
crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial.
But you're saying
Because of
it's
that, she doesn't
self-defense.
have to prove anything.
If it's self-defense, you're saying she
That's
did
why the
it.
state went first in jury selection. That's why the state went first today. That's why the state will go first
You're
later on
presenting an
today.
affirmative defense.
They have the burden of proof,
So you're
and
saying
it's the
that she
highest
did.
burden we recognize in any type of litigation.
You're saying she did
this
it,
country.
but it was justified.
Proof beyond and to the exclusion of every
Okay.
reasonable doubt. You are going to have doubts about this case.
Doubt that it was self-defense, or
But the
doubt
most important
that she
thing
did it.
is not to rush to judgment, to keep an open mind, and understand there's two sides to this case.
You're arguing two different
There's their
things.
side and there's our side.
Here's why I'm so frustrated. A, I couldn't be more critical of the prosecution. There's room to be critical of the prosecution because we couldn't fucking hear him at all. So the reason I am being more critical of the defense is because I can hear them. It's hard to critique what you cannot hear well. The defense is arguing there's doubt in this case, but he's arguing self-defense. So what he's trying to argue is she's not guilty because of the self-defense, not because the state's not proving it beyond a reasonable doubt. So he's conflating the two arguments, which is just incredibly confusing to me, because if it's self-defense, then you're not arguing there's doubt in this case and how do you know she did it? You're arguing there's a reason that this happened, and that reason makes it justifiable. And because of that justifiability, she's not guilty because of the defense. So he is conflating the standard of proof and his defense, and that's really frustrating because it sounds like he's going to be arguing it was an accident, it was not intentional, but she was trying to forestall an attack and that was intentional. Well, if that was intentional, then she intentionally zipped him into a suitcase to defend herself. So that's not unintentional.
You can't form any fixed opinions early on.
And that's really hard to follow.
That's hard to do, as Mr. Henderson said in
The problem,
already.
you guys are saying there's two sides to every story.
That's extremely
Yes,
hard to do.
there's two sides, and the defense has three sides to this story. And then there's the
You're gonna hear some
prosecution.
testimony,
The defense needs one side.
which been mentioned by experts.
I need to
Battered
pick
women's
one.
experiences affect her perception of imminent danger. Battered women's experiences
Should have started with this earlier.
affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law.
Interesting that he doesn't say we're
And the
confident you'll
justice
find
in
this
this
as
case.
self-defense.
And find Sarah Boone not guilty. Because it's the right thing to do. Thank you.
He also said she was
Thank you, sir.
waiting for George to come
The
up to
party's first
bed.
for a moment.
So if she's waiting for George to come up to bed, she zips him up, they're playing a game, and she's waiting for him to come up to bed. I don't understand how that is her being afraid in that moment and restraining him because she's afraid in that moment. But we will see. Open mind, right? They have approached. We are done with opening statements. We're going to be moving on to witnesses shortly. I'm excited that the audio should get better as everybody's closer to the microphone. We're going to zoom this sidebar as they call their first witness, and we're going to get into the prosecution's case in chief. Remember, the prosecution bears the burden. Under the eyes of the law, Sarah Boone is innocent till proven guilty. It is a hard side of a coin with this, though, because she's arguing I did the thing, but I had a reason to do the thing, but then also arguing I didn't do the thing. And those two things are so contradictory. It's going to be really hard for the defense to navigate. And we saw a little bit of that in opening. So they are going to be trying to navigate it. The prosecution goes first with all their witnesses. When they rest their case in chief,
State,
then the defense.
you may call your
goes.
first witness.
So now we are on to witness
Juan Torres.
number 1, Juan Torres. And we are off and away in trial. What was striking to me with the testimony, or not the testimony, with the opening statements, is how much agreement there is on the facts here. The facts are the facts. It's just, is it justifiable or not? And that's what this is all going to come down to. I see a lot of you asking how long will this trial be. The defense said they think they'll be in their case with her testifying at the end of next week. The jury was qualified for 3 weeks. I think it'll be shorter than that, like a week and a half ish. But the jury was qualified for 3 weeks. Oh yeah, no break for the jury.
Circuit Morning, you could be seated. And once seated, if you would state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
Six or so.
6 or 7?
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. And Massachusetts.
Your brother, how
I
often, your brother
Sir,
George, that is.
I need to know where.
How
and
often
when.
would you talk with him?
Often we talk, say, on a weekly basis.
For those of you in the chat, I didn't mean 6 or 7 in a derogatory way at all. I think he is probably processing whether he I don't know, either counts his deceased brother, and he looks incredibly nervous. So I understand why he would be like, it's going to take me a minute to tell you how many siblings I have, especially if siblings are deceased. So I get it. Also, I think he is probably incredibly nervous.
And how far away did you live from George?
About 5-10 minutes. Very close.
Would you see him pretty often?
I try not to go over there too much.
Interesting.
Who was George living with at the time that he passed away?
Sarah.
And without getting into many details,
Do you
what
see
was your
her?
relationship like with Sarah?
We didn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
He said, I try not to go over there too much. That was clear. Clear as day.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, Can you tell us what the topic of that conversation was?
We were just talking like we normally did.
Chatting.
He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it.
It's like, all right, time to go.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
In cross-examination.
Interesting first witness. He was talking to his brother. They were on speakerphone. Sarah was in the background yelling about him choking her. It's an interesting first witness.
Good morning, sir.
Mhm.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
In Orlando.
Okay.
He has other siblings elsewhere.
Now, did your brother Jorge Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
No.
All right, sir. Let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
All right. And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay.
Didn't sound drunk.
He
Is
wasn't
what he's
slurring his
asking.
words or anything like
Right.
that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No. Because I knew when he would drink.
Okay.
He could tell.
So, in your opinion, at that time, based on what you heard and what he was talking about, you
I'm
do
actually
not
surprised the
believe he had
prosecution
been
didn't ask
drinking
this. It's good.
alcohol?
It's a good question, but better for the state.
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
Nobody's
I
identified
can
her
tell
in court,
her voice.
You recognized her voice.
which is a problem for the
So
prosecution.
you could hear her. Is that correct?
Yes.
All right.
The prosecution should have said and didn't say, do you see her here in court? And have her be pointed out. The Sarah you heard on the phone, is that person sitting over there? So they've never identified the defendant. We'll see if the defense does it, but that is an issue.
And you've heard Sarah speak before that time, is that correct?
Yes.
And you've heard her speak on the phone before that time, is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes.
And she was yelling about, he's choking me. Or tell him about choking me.
That's not what he said. In his
Yes.
compound.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Good question.
Not really.
You've heard it before?
No.
Then why wasn't it a surprise? It's a good question. If you follow up with, why wasn't it a surprise?
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No?
I see a lot of conversation in the chat about the fact that the judge identifies Sarah Boone for the record. The judge does identify Sarah Boone for the record. But how do we know that the Sarah Boone this man is talking about is the person that is sitting in court? So each witness needs to identify the person they are talking about is the person that is present in court. You can't just do it by name. There's lots and lots of Sarahs. So it should be identified for the record. With this testimony, will it be that much of a problem? Maybe not, but I would be interested to see if anything comes of it. Just a note, it should be identified for the record, and it's a problem. The judge identifying her just means that's the name of the person in court. It doesn't mean that's the person he heard on the phone.
Sir, at some point your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have.
Nobody identified it for the record.
You may, sir.
He's going to do it now, I bet. No, maybe not. I thought the prosecution was going to be like, can we just, real quick?
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
That's probably questions from Sarah.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
Okay. Interesting.
State would call Devin Jamro.
State's witness too. Also, for those of you that watched the Karen Reed trial with me and are like, why is this moving so fast? This is more typical. You've got a few things you need from each witness and you just get that moving. So this is not a surprise that they're moving through fairly quickly. So. Nicole asked if attorneys get to choose the order they want their witnesses in.
Sir, good morning. You can take a seat and please state and spell your
Yes.
name for the record.
But scheduling.
My name is Devin Jamro. That's DEVINJAMRO.
We can hear you,
Thank
Devin,
you.
loud and
You may
clear,
inquire,
buddy.
sir.
Thanks.
Sir, who do you work for?
I work for Publix Supermarkets.
And what position with Publix supermarkets?
I am the assistant store manager.
And at what location?
Currently the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Hopefully that adjusted. I adjusted it. I hope it adjusted on your end. Why aren't we just asking what? Okay.
Your Honor, may I approach the witness which has been previously marked for identification as States D and been shown to defense?
D's and Delta?
D is in Delta.
Yes, you may.
I agree with you, Chad. I also love a Publix. It was very pleasant finding Publix when we
Sir,
moved
I'm
to
showing you it's
Tennessee.
been marked for identification as States D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
It's probably video from the store, given what we heard in opening statements, that this witness is going to be like, yep, that's the store. Yep, that's what I saw. That would be my guess, unless it could be a receipt. Emily, just let him open the thing. I know. I can. I really like Publix. I mean, I really like Trader Joe's too, but I really like Publix. For the international law nerds, it's a supermarket, a grocery store. It's a good grocery store. Their
Sir, do
pre-made
you recognize those
items
items?
are great.
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep. Yeah.
Your Honor, at this time I'd like to move what's previously been marked for identification as States D into evidence.
Any objections?
No objection?
What was pre-marked as States D will be received into evidence without objection as States 1.
All right, he's just business recording in the receipts from Publix. I don't know why they are. I don't know what the purpose is of being like they bought the wine that day, but they want to prove that they bought the wine that day. So they're bringing in the receipts to be like, this is when they bought the wine.
Previously marked for identification as States J and shown to defense.
You may.
So I'm showing you it's been marked for identification as States J. Can you take a look at that disc?
Yes.
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did. Yes.
They're
And
just
tell us, what is that disc?
cruising. through
This
the
is
foundation.
CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of business, are the videos from those surveillance cameras kept?
Yes.
And are these the cameras taken from February 23rd, 2020? And I believe there's two video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.?
Yes.
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
They do. Yes.
Your Honor, at this time I'd like to move what's previously been marked for identification as States J into evidence.
Any objections?
No objection.
What was
So they
pre-marked
are
as States J will be
moving
received into
through the
evidence without objection
foundation.
as States 2.
Of the store. I see many of you in the chat saying proving up what was purchased contradicts things Sarah Boone said in her
cross-examination?
interviews.
Can this witness be released?
Yes.
Since her
Thank you,
interviews
sir.
are
You're
not
released.
in yet,
Thank you.
Have a great day.
I don't have that knowledge. I did not watch them, so I'm waiting for stuff to come in. So I will comment on the things I see as I'm waiting for it to come in.
State, you may call your next witness.
State will call Joan Williams.
I was waiting to see why where everybody sat at the basketball game in Canton was relevant. It never came up, so if it contradicts things she said, then it will be readily apparent when we get to her interviews next week. State's Witness 3. I like her jacket and dress.
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Joan, your outfit
Good
is
morning, ma'am.
amazing.
Can you tell us what it is that you do for a living?
I'm a 911 call taker.
Thank you for your work, Joan.
And how long have you held that position?
24 years.
Wow, Joan.
And tell us, what are your
That's some
duties
shit.
as a 911 call taker?
I answer phones for emergency, non-emergency, medical, which I transfer to the medical side of business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911
She's
calls?
like, yes.
And those records are made at or near the time of each call, correct?
This all lays
Yes.
business record foundation. That's why he's asking those same questions, but it's a very smooth foundation laying. It's just question,
Your
question,
Honor, may I
question.
approach the witness, which has been
Boom.
previously marked for identification as states L and been shown to defense?
You may.
Yeah, 24
Ma'am, I'll show
years
you what's been
on
previously
911
marked for
lines is
identification as states L.
a
Do you
lot
recognize this disc?
of work.
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case?
Well, now I can hear
on February
everybody.
24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
And this witness be released.
Yes, Your Honor.
Thank you, ma'am.
I appreciate that they're just like, foundation, we're going to lay foundation for everything. Boom, boom, boom.
The parties
boom.
approach momentarily.
I imagine the judge wants to talk about scheduling or Joan's fabulous outfit because snaps for Joan. We love to see it. All right, I'm going to zoom.
State, you may call your next witness.
State will call.
I
Vincent
imagine they were talking about
Battaglia.
scheduling and lunch. The state said they wanted to get moving, and they weren't fucking about. The state's like, we want to get this going, and they're like, and what we're going to do is lay all of the foundation in 4 questions, 7 seconds. Just, I love it. Great pacing. Sir, can you turn this way so we can see your sleeve?
Sir, you may be seated.
Very
After you're seated, if you
up
can
in
state
here.
and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Hello,
Good
Vincent.
morning, sir.
Morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Them.
That's Brandon Moats?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year. A little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah. Like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
Do you see your neighbor?
This
in court?
Tealwood apartment complex, how would you describe the walls that separated your units?
Thin. Like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
That's leading.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
Leading.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It
was
was
this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, probably 4 to 5 months before that.
So 4 or 5 months before February
Of 2020. Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like, if I do hear anything, like through the walls or whatever, that's out back, just kind of keep my mouth shut, like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Huh.
Did she make any motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like.
Interesting
That kind of
that that's
So she
What she
told
said.
you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there.
Yeah.
Interesting that it's in that
Do you
video.
recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer,
Like, what the
was
fuck?
that? And I was like, I have no idea.
yeah.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like and kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. at the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah, all the time. It was like a back and forth. Yeah.
So other than the statements and the phrases of I hate you, you weren't able to discern
police it was a good day.
the contents of this argument.
No.
Because she knew it would look bad if they were arguing and then he died.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that, it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, Then it was just like a loud rumbling noise, like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Any cross-examination?
He didn't identify Sarah. Why are we not identifying Sarah?
Mr. Battaglia, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year?
Yes, sir.
Are you
so
aware
confused.
that the police were called to their residence
Like,
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever, the year that you were there living next to them,
Yeah.
were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
Right. And did you work odd hours or you went?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and
class
stuff
at
like
1
that. So yeah.
I have questions.
Do you have an opinion
Were you
as to
studying
whether or
abroad
not,
remotely?
based on your interaction with Sarah
I'm
Boone,
not going to object.
Let me finish the question first, please.
do you know from your experience with Sarah Boone and your experience with George Torres that they drank alcohol?
Yeah.
Hang on.
Lay the foundation for it.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you.
Yes, sir, of course.
They drank a lot. I don't think anyone's going to contradict that they drank a lot.
Well, Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement?
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object as to improper impeachment.
Approach.
Oh, all right. It sounds like they are trying to impeach him with a prior statement to police. The prosecution has said objection. That's improper impeachment.
got home around.
So we'll see.
Sir, would it be fair to say on that date you got home around 7 p.m.?
7 p.m.?
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
Where
In the
were you
morning?
working?
No, in the afternoon. Because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
Thanks, Ari.
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you.
All right. So he heard them arguing around 10:30 at night. It'll be important because the
He
video
redirect.
of the suitcase is
Very
time
briefly.
stamped.
Yes, sir.
It seems like there was it seems
So
like
on
there was an argument leading up to the
cross-examination,
suitcase.
you were asked
Not just giggles.
about the arguing.
I'm going to pause to all of the Full Sail student and alumni in the chat. Thank you so much for explaining that it operates 24/7 and that classes at like 1 a.m. aren't the weirdest thing ever. Oh, you guys, we must be on trending because we have bot spam comments. Oh, it's the first day of trial, y'all. We've made it. We've made it. Somehow they have managed to evade some of the limits for emojis, but don't worry, Nightbot will catch most of them. But y'all, let's go! Day 1 of trial. Yay us, kids! Look at us. Look, Ma, I made it. Don't worry, we have a bot to fight the bots. That's what happens. So when you guys are like, I hate it when the bot gets me on the emojis. At times like this, it is so important when the emojis are all just like ridiculous shit in the middle of a murder trial. So yay! Thanks, Nightbot, and thanks, Law Nerds.
I believe your testimony was that it was pretty intense around 10:30.
Oh yeah, because we have over 20,000 in the chat. That makes
Approximately
sense.
what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
Nope.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, Your Honor.
Not subject to recall.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes.
They're asking that this witness is subject to recall. This witness is probably one of the important out-of-state witnesses that we heard about. He currently lives in New Jersey. So he is saying, the defense is like, we want him subject to recall. It's like, fine, then you're going to have to fly him back down here because this witness needs to get home. He said they had important out-of-state witnesses they wanted to get through. I think this is probably one of those important out-of-state witnesses because he is testifying that not everything is, fun and games earlier on in the evening, that they were in fact arguing, but that argument can go both ways because the defense can say, right, that's why Sarah was afraid. They were arguing. She lied to police and said everything was good, but they were
All right, sir.
arguing.
You
and
are
she was
released,
scared.
not subject to recall. Have a great day. Thank you.
That's been resolved because he's an out-of-state witness. And if the defense doesn't have him under subpoena, they
State would
can't
call Brandon Moats.
just keep him subject to recall when he's from out of state.
Bless you.
All right. Next witness. Have I already lost count, Emily? It's like we're moving so fast. That was witness 4. We're on state's witness 5. Yes, y'all,
Thank you, sir. You can
for
be seated.
all of you commenting.
State and spell your name.
I thought he was going to fall for a second. For all of you commenting, hey, this is moving fast. Yes. But it's because we have seen so many trials where they have asked so many questions that don't matter to the case. This is very tailored to what are we doing in this case? What did you hear? What did you see? Where did you live? Great thanks. They don't care what time he ate or what he was having to drink or if he went outside for a smoke. No, what did you hear? What did you see? What did you do? What did you say? That's it. So it's moving much quicker because it is incredibly focused.
For the record for us.
And I appreciate
yeah, my name is Brandon Moats, BRANDONMOATS.
The roommate.
Statutory, you may
Of the
inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so, when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So
I'm
she
sorry you
was
had to go
your
to
neighbor
college in
at Tealwood
2020,
Apartments,
sir.
is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with Jorge Torres in this case?
Honestly, I avoided them as much as possible usually.
Why was that?
The apartment where you lived.
So he didn't identify the defendant. Emily, are you stuck on this point a little bit? Because it is ingrained in my experience as a trial attorney, but different jurisdictions are different. Did you have many interactions with the defendant? The defense didn't object to say the defendant has never been identified. Everybody is just skipping through it like it's cool. So I'm just going to be like, okay, I guess we're cool. Don't worry. I'm going to text Peter from Lawyer You Know. He's a Florida lawyer, and just be like, Peter, what? Maybe he'll cover it in coverage today, and then we'll find out the answer together. But I'm stuck in a loop until I have resolution. But he said with the defendant, just assuming it's the defendant, and nobody objected. So this is clearly not something that is out of the norm for this courtroom, for this trial, and it's not something that any of the attorneys in court seem bothered by. So if they're not fussed, I should not be fussed. I'll try. So we've all just assumed that the person sitting in court is the person that they're all talking about, and that's all great. But I wanted to point it out because there was no objection, and I'm very interested to hear if or why this individual avoided them as much as possible. I think we all know what's coming, but I would like to know.
Tell us, how would you describe the walls that separated the units?
Yeah, I remember that my bedroom was like the front-facing bedroom, and our walls shared a wall with where their staircase was. So, like, the way the apartments were laid out, we had a one-story apartment, they had a two-story apartment. So they had a staircase running right next to the walls, next to, like, our bedrooms.
Huh.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin, so if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them.
That's a stressful living environment.
Very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably. Like, earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that, would it have been on the first floor or the second floor?
We had a first floor apartment.
Okay. So all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the one
And
floor.
the stairs ran by the bedrooms, and something shook the wall.
And at a
Something
certain
shook
point
the
in the
wall
evening,
after 11 o'clock at night.
did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling, and it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me. Like
That's what they both
like it was
described.
falling down the stairs.
Like something was falling down the stairs.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally like it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, I never saw her after that happened.
He's like, I didn't want to. He's a great
Hey,
witness. Him and his
cross-examination.
roommate. This is what I love about him and his roommate. The prosecution's questions, though sometimes leading a bit, the prosecution questions are so direct and to the point, and some of them are just foundational and narrow, but they are just direct and to the point. So they both are literally just testifying to, on this day, I was in this place and I heard this thing. There is no addition. There is no selling. There is no extrapolating. There is this weird thing happened. This is what I heard. It is just incredibly factual testimony. I love seeing witnesses like this. It is the type of testimony you expect when somebody's like, this weird thing happened this day, and this is what I remember about it. I think they're great witnesses. It's been a minute in trial since we've seen witnesses, especially because the last cases we've covered have been so wild, that you see witnesses just come in and be like, yeah, this thing happened. That's it. Just fact-based testimony. It is incredibly refreshing. Anyway, I like these witnesses so much. A thing happened, they heard it, that's it. But I'm beginning to worry that the victim was tumbled down the stairs
Good afternoon,
inside the suit.
Good afternoon.
Sir, you were asked by the state if you ever had any
On to cross?
interactions with Sarah Boone or Jorge Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yes, you did say that.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
It's like, I'm going to nope right out of that.
Do you remember this interaction
I love him.
with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019 when...
I love this witness so much. He's like, I am not having any of this bullshit. Sir, I would have been 9. A, I've just been called old. Help, girl down. But B, he is just fantastic. I really wanted the prosecution to follow up on why he avoided Sarah Boone and George, because I think we could understand why he was. And you can see his discomfort with, yeah, I don't want to be around people that are drunk and screaming. And they were often drunk. I'm inserting the and screaming. We're just going back to relive this icon's moment of testimony because it's too good and I adore it. And I'm going to shut up so we can just appreciate appreciate this testimony so early on trial. We just love a good witness. I went back too far, but
Both of our rooms.
You're great, Brandon.
I never saw her after.
Yeah, I never saw her after that, but she went to prison or jail.
If you ever had any interactions with Sarah Boone or Jorge Torres, is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah.
Mood.
I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Okay. Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah
I
sleep?
would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
Okay. So you did not witness that yourself? Or
Heard
did
from
you
his
see
roommate.
her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay.
He's like, your question was imprecise.
Another time,
I'm not having it.
do you recall our interaction with Miss Boone when you were coming home from school and she
The sleeping
was
on the
trying
patio was
to talk to
2019.
you, and she seemed paranoid and rambling?
These are
Yeah,
statements
I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying, because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go home.
She was procrastinating.
I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the boom, which was like 10-something, initially it was around 7 p.m. You heard arguing?
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after I
appreciate how he's recreating the day.
Came home,
That
I
makes so
made
much sense.
myself lunch, and I took a shower, and then I heard all of their
This is what I
arguing, so it
did.
would have been about an hour and a half, 2 hours after I got home, so around 7 to 8 o'clock.
Your grasp of time
And
is
during that time, when you
admirable.
say arguing, was it back and forth?
I honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth.
Did you hear
Let me
both
ask you
voices?
this. Did you hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay, were they
Right.
both loud?
Yes.
Right. He can't. I love this witness so much because he's like, I'm not going to assign action items. I'm not going to sign back and forth. I'm not going to detail the argument. I heard two voices that were yelling. He is A, incredibly attentive in listening, and B, he is really trying to be precise with making sure that nothing is misinterpreted or that his words aren't misconstrued. Very much I can't say if it was back and forth, but I heard two voices. Appreciate his clear and concise and thoughtful testimony.
If I can confirm, Judge.
Yes, sir, of course.
Peter's made me feel like I'm not going crazy.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right, sir, you're released subject to recall. Thank you.
Okay, y'all. Peter texted back and said, "No, they definitely have to. It's
The
not
parties approach.
nothing different." He's like, "It's wild that they didn't hit it." I'm like, "Great. Okay, it's not me. We're all on the same page. It is wild to me that they have not taken care of that." So, what a great witness. We're going to zoom until the court's back on the record. I imagine they're going to be getting ready for a lunch break. Because that seems to be about what time. And we are
21. At this point, members of our jury, thank you so much for your time, your attention, and your participation in this very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers.
What about YouTube?
Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, please leave your pens and your notepads on each chair. The deputy will collect them. We'll see you at 2 o'clock, and I thank you for your service.
Your Honor, I have some addendums. I have some addendums about Reddit, social media, YouTube, beyond local news. I think they get the point, but I think those model instructions need to be updated. They're breaking for lunch. Is that length of a lunch break normal? Yes. Some courts, like LA County, for example, has a mandatory lunch break because of union requirements for court reporters and others, which is appropriate to have an appropriate rest period, especially with the manual transcription. So it depends on the jurisdiction, what the lunch hours are, what the rules are, what the amount of time is needed for Sarah to get lunch as well.
Defense. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am, before we release. Are you satisfied with your attorneys so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed?
She said definitely. I am shook. Ma'am, are you satisfied with your attorney? I've never heard a judge ask a defendant this before, and she said definitely. What? I'm back. We're going to run that back again.
Defense. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am.
Never seen a judge do
this.
this.
Satisfied with your attorneys so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed so far in this trial? All right, thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
Shocked. I am shocked. I thought we were going to be just playing You'll Never Be Satisfied from Hamilton this entire trial. But no, they are inquiring, and she is happy with it. Maybe it's just the clothes. She's like, I have clothes. I feel good. I feel like I'm being heard. But that's good. She should feel like she's being heard. She should feel like she's supported by her defense attorneys. I'm just surprised. I am just surprised. You know, I don't know if we need to watch them pack up the courtroom. Let's get to Q&A. We are going to be taking a bit of a longer lunch here because I have a mandatory meeting. And instead of missing the witnesses that are coming after lunch, I am going to take a lunch break for a little bit longer. So chat, I am letting you know that I will be back at 2 p.m., not Eastern. I might be back a little sooner. We are going to leave the stream open. No spoilers, thank you. I'm going to do Q&A now, but we will, and a bit of a summary from the morning, but we will be back by 2 p.m. Central because I have a call. So 2 p.m. Central time, which will be what, noon Pacific and 3 Eastern, and that'll give us some Zoom room. And we've also run a little bit long. It'll give me time to eat lunch. But this meeting was, it's a lot of people and it cannot be moved. There is some of that going on. It is fall. I have some things I just must attend and I don't want to miss. The witnesses are going so fast. I don't want to miss that. So I'm letting you all know in advance. We will also let you know in the app. If my meeting ends early and I am able to scoot, I will be back early because we're going to leave the stream open. But I want you guys to take care of yourself. Get up, move, get some food, get some water, stretch, enjoy. I don't know, open your mail. Let's do a little bit of Q&A, shall we? And then we will zoom to lunch and we'll play. We've got our new like hold music for you. So don't worry. We've got the things. We'll decide on music in a minute. Let's see if we can do a real quick summary of the morning, shall we? We are at the lunch break of day 1 of the Sarah Boone trial in Florida, and we have gotten through opening statements and 5 witnesses from the state. Yes, 5 witnesses and opening statements before the lunch break. And that's with the court starting almost an hour and a half late because they were still arguing motions. Once the motions got done, this trial has moved along swiftly. The prosecutor's questioning has been direct and to the point. So far, the witnesses have been direct and to the point. The cross-examination has also been direct and to the point. So as we are now, this trial has been moving right along. The jury has been qualified for 3 I said that very weird. The jury has been qualified for 3 weeks. I don't think they will need it. And what we heard in opening statements from the defense after the microphones in the courtroom were all turned on, we heard them say they think that the jury will hear from Sarah Boone next week. It is Friday, October 18th. That means sometime next week, we will be hearing from Sarah Boone on the stand. We will see how that goes as we get into early next week. And I cannot wait to see what is going to happen. But as for opening statements, it was rocky for the prosecution in that it was very hard for us to hear because as the prosecutor was away from the podium, the microphones in the courtroom were not picking up the prosecutor's opening statement well, and that was difficult for the audience at home. For the jury, I think it was fine. Opening statements, we did get the prosecution's recitation of the video that is central to their case, where the victim, Jorge Torres, is inside the suitcase and Sarah Boone is mocking him as he is saying that he can't breathe. So the prosecutor went through, like he did yesterday in motions, just the transcript from that. He went through transcripts of some text messages back and forth with presumably Sarah Boone and one of George's brothers, where she is seemingly rambling on in text. And then the brother says, you know, Sarah, get that help that you need. God bless you. And she talks about making George disappear and things will be, all caps, better. The prosecution also talks about the fact that she chose to leave him in the suitcase, that he could not get out, that the suitcase was zipper side down, the top of the suitcase was down, and he couldn't get out of the suitcase. Then it got a little lost in analogies as he was away from the microphone talking about mutual violence in the relationship, talking about violence from the victim towards Sarah Boone, but also talking about the fact that Sarah told law enforcement that on this day, everything was great. They had a lovely evening. They drank some wine, they painted, they did puzzles together, and they were messing around. and playing hide and seek. Now, as we get into the witnesses, there's a little more information there. The defense said, buried in the middle of their opening statement, that Sarah Boone, quote, loved the man, but not the abuse. And I think that's what they should have led with in their opening statement. And it should have been the theme of their opening statement that Sarah Boone was in this relationship because she loved Jorge Torres, but she did not love the abuse, because that plays into the defense that they are going to be bringing. Where things got a little lost for the defense in opening statement is when they were talking about the fact that this was an accident, that it was not intentional. They said Sarah Boone lied to the police because the police were trying to make this seem in her 2-hour interrogation like it was an intentional crime, and it wasn't intentional. And so she lied to the police. But then he said that it was self-defense, that though it was unconventional, he called the suitcase a unconventional method of restraint, and she was restraining Jorge Torres from attacking her. Well, then that is intentional, not accidental. So there were times that the defense seemed to be arguing two conflicting theories of the case between the self-defense and between the she didn't have any intent to do this and she thought he could get out and that would be fine. If she thought that he could get out, then how is she restraining him so she's protected? I found parts of that opening statement to be internally conflicting. And if that doesn't straighten out, it's going to be tough, because the defense needs a very clear message to the jury, and hedging your bets in opening should look like saying less, not saying everything. And I don't think they narrowed that down well. But they did talk about what Sarah Boone will testify to. Sarah Boone, we know, is going to testify and has to testify. So much of the opening statement relied on what Sarah Boone will tell the jury. So really, I think the jury's going to be waiting to see the video evidence and waiting to hear Sarah Boone testify. And then we got into the civilian witnesses, and the 911 operator. The 911 call was authenticated. The receipts and store security video from Publix were authenticated. And then we got to Sarah Boone's neighbors. Both neighbors are young men that were living there while they were going to college, and they talk about the night that this happened, and both of them describe hearing a loud crashing and boom thump that shook the walls of their apartment. The second witness described the fact that the bedrooms in their one-story apartment back up to Sarah Boone and Jorge Torres's townhouse-style apartment, and the staircase goes down behind where their bedrooms are. And so it sounded to the witness like something started making noise above his head in the apartment and then came down past his apartment to the bottom. Both witnesses described a similar thing where the noise was farther away and then got closer. It sounds very much as if something was, or someone was, coming down the staircase. And I am concerned that was the victim in the suitcase. I don't know what more we will hear about that, or if it will be until closing arguments, but that's sure what that testimony sounded like. Both of the roommates who had lived next to Sarah Boone and Jorge Torres, I thought were great witnesses. Very factual, very concise, very precise with, this is what I heard, that is not what I know, this is what I know. And both of them talked about the fact that there was lots of arguing constantly. And one of the roommates said in his testimony, when asked why he kind of stayed away from Sarah Boone and Jorge Torres, yeah, exactly his testimony. Yeah, I don't like being around people who are drunk, and they were drunk a lot. And it was very clear that the level of intoxication and screaming back and forth was uncomfortable for both of these college students to live next to. And it was why they kind of noped out of interacting with Sarah and Jorge Torres. So with all of that, I have one outstanding question. I don't know if the question is great. It is pending. It is a pending question. Why is the prosecution not asking the percipient witnesses to identify Sarah Boone in court? Because Sarah Boone is sitting in court, and they keep referring to Sarah, and they have not said to anybody, hey, is that the Sarah that you're talking about sitting there? Or, hey, do you see the Sarah that you're talking about sitting in court? Jorge Torres' brother briefly testified at the beginning of this case and never identified Sarah sitting there in court. The two roommates who lived next door to them never identified Sarah sitting there in court. They've never identified the defendant. It's wild to me to watch. And at one point, the prosecution refers to Sarah Boone as the defendant, and everybody agrees, and the defense doesn't object. But I'm waiting for the other shoe on that, because we've never talked about who Sarah Boone is in court. So we will see what happens, but they should be tying together that the person they're testifying about is the person they see in the courtroom. So we'll see what happens. So with all of that, let's get to your questions. I've got questions, you've got questions, we've got questions, and we need to thank everybody who has so generously super chatted and gifted memberships. I know I did not get to thank everyone who gifted memberships individually, but I've seen so many of them come through today. So thank you and welcome to all the new members who are experiencing the glory of not having slow mode when you want to chat, because that is a very big deal. Megan said, I am not trying to be mean, but are these real attorneys? It doesn't seem like they know what they are doing. I think the attorneys, particularly the defense attorneys at this point, are incredibly discombobulated because they have not been on this case long enough and they are moving in a lot of different directions. So there is a level of discombobulation. Matt Bond said, well, hello, spiffy legal mumbo jumbo talkie sister from another Mr. On the record. For the record, let the record show lemonade in motion. Matt Bond, it is good to see you, friend. Nice to see you in the chat. Bit of levity. See you at Metallica. Yay! I am so excited for Metallica in May. I'm so ready. I am so ready. Live music is good for the soul. Jennifer said, I pray that they ask Sarah during cross if you left an opening for George to get out, and when he used that opening to get out, you were triggered to beat him. How was he supposed to get out? That's a very good question, because as his fingers were coming out, that is when it seems that she started hitting him with a bat. We will see. But yes, there are lots of conflicts here, but less objections than I thought we would get. Just not a lot of objections so far. Surprisingly so, actually. Danielle said, thank you so much for stopping to recap so we can keep up due to the wandering. You are welcome. I know there are some that are like, can you please never pause ever? And there are some that are like, no, I appreciate it when you pause and kind of catch us up to where we're at. So I rock with what works for my neurospiciness, but I also figure the internet is vast and wide. And though this is the #1 place to watch trials on the internet by live concurrent numbers, everyone has choice. So if it works, it works. And if it doesn't, it doesn't. So that we just roll with what works for us because we're the Law Nerds. Tracy, thank you for the gifted memberships because we're the Law Nerds. Oh, excuse me. I wonder if my boss could use Brandon's trial as deposition trial prep for his clients. It's just so good. I mean, it's on the internet. It is good witness testimony. It's like, what does a good witness look like? And if people have never seen trial testimony before, it's hard to explain to someone, no, you just need to stick to what did you hear? What did you say? Listen, make sure they're not putting words in your mouth. Make sure that what you're answering is what they're asking, and make sure you understand and ask questions back and narrow it down. It was great testimony. Absolutely great testimony. BB McD said, are they maybe guarding against ineffective counsel by asking that? Possibly. I mean, possibly. It's just not something I've ever seen a court do. And so I appreciated it. Richard said, best laugh ever. The swiftness, look, the 2000 babies, the humans born in the year of our Lord 2000 have such an easy time, because he was like, so in 2009, I was 9 in 2000, like no math required. I was 9 in 2009, like just nailed it. Just immediately nailed it. It was so good. It was so good. It's like, he's like, oh, good catch. I mean, 2019. It's like, sir, I was a literal child. It was so good. It was just so good. Krista Limited Edition said, yay, 5 months. Thank you, EDB mods and chat for the amazing community. Lots of laughs, learning, and some emotional tears. Yes, that is the experience. Love being a law nerd and the new app and lounge. The lounge is so good. P.S. Thank you for the new Pokemon Go Sleep Adventure. Isn't it fun? I love Pokemon Sleep. It really is. It's one of those casual gaming things that I can just kind of peep into a couple times a day and enjoy. Danny said, a lot more fun listening with you than just on Law and Crime. And look, there is room for all of the channels. It is the internet. It is vast. YouTube does not bandwidth cap us. So there's tons of room for trial without commentary and then room for trial with commentary. And I think it's great to get to pick. And then if people want to go see a moment of trial without me yapping about it, there's room to just go find the trials on the internet and be like, oh, it was when they were talking about this. I want to hear it. I do try to make sure if I talk over something entirely that I think is important that I back up and shut up about it, but not always. That does not always happen. Steven said, so we don't know which countertop he sat at. We don't know if it was a high top. We don't know if it was a low top. We don't know what time everybody got home. No, they just asked the questions relevant to the thing. Malia said, I wish we had a separate feed for his internal monologue right now. I don't know what time in trial this was from, but yes, for all of it. Yes, for all of it. Carrie asked if I could summarize the opening statements. I hope that my summary helped. We also do summaries on the Quick Bits channel, and I think we are going to try to sound boost some of the openings and clip some of the moments of opening statement into our Quick Bits so that we have a summary. If we are able to sound boost them, I will also put them up on our Law Nerd TV channel and link them in this video when it is done. So if you are watching this in the future, I will link videos of the prosecution opening statement and the defense opening statement if we are able to sound boost them a little bit. It was tough. So that. Let's see. Kylie said, is the Richardson hearing from yesterday the reverse of Brady? I think we talked about that. Also, my doctor's office has the best framed DMB poster from the Gorge. I have a couple Gorge posters. I am starting to put them up in my office. My band is getting inducted. I mean, not my band, but you know, my band is getting inducted into the Rock and Roll Hall of Fame. They are going to be honoring Leroy. I am so excited for the Dave Matthews Band. I'm so excited for the incredible musicians that are going to be honored into the Rock and Roll Hall of Fame. The way I have been so tempted to just hop on a plane and go to Ohio. The way I am so tempted. And I'm like, Emily, we have court. We are covering trial. Your kid has band competitions. Like, breathe. So y'all keep me grounded because I would be exhausted, but I am so tempted. I am so tempted. Emily, do you want to get on a plane? Yes. Yes, I do. Yes, I do want to get on a plane. So chat, because I have meetings coming up, I have got to jam and get a little bit of lunch. I suggest you do the same, or some food, some chat, some snackies. Get your snackies. Let us know in the chat what you're snacking on. The Law Nerds and the Law Nerd Lounge were chatting last night about what their trial snacks are, and I love hearing it. So trial snacks for all of us. I am going to need it. We are going to be on lunch for an hour and a half. I will absolutely ping you when I am back so we know, and we will do all of the things. So take a break. Know that I will be back. You will hear all of the background. Beats Kill Bean said I'm going to the induction. I can't wait. Share pictures. Just tag me in the things on social, share pictures. It's going to be great. It looks like it's going to be a great show because so many great artists are being inducted into the Hall of Fame this year. Jelly Roll's going to be performing. I just love it. How are they handling the Rock and Roll Hall of Fame? Does that include Boyd? It sounds that Boyd's name will be there, but he will not be at the ceremony from what I've heard. And they are absolutely honoring Leroy and some of Leroy's I think one of his saxophones is going to be part of the Dave Matthews Band display because Jeff Coffin is bringing it with him to the Rock and Roll Hall of Fame. So there will definitely be honoring for Leroy, and I'm so excited, but I just can't get on a plane. I wish I could, but also I know I'll be exhausted. And you know, your kids are only young once. I will get to watch it on TV. It will be fine. I am not being inducted into the Rock and Roll Hall of Fame. Though when you've been going to live concerts for a band since, I don't know, when was my first live show for Dave? 1996? it feels like you are a part of the family because it feels like a large fandom family. So I'm excited. All right. Law Nerds, I will be back. Danny asked a great question that caught my eye. Danny H said it seemed like the prosecution asked a lot of leading questions. Oh yeah, they did. They did. Some of it was foundational questions. The defense was not objecting because I think the defense was like, can we get through these? Like for the gentleman who's the manager at the Publix, is this your CD? Is this? Great. So it really, some of them were leading when it came to the civilian witnesses. The defense could have objected on a few of them. I think I pointed it out a little bit, but also they were moving through so quickly. Some of those were foundational to just direct the witnesses to the point in time. Like at some point, did you hear yelling? What did you hear that night? Something drew your attention that you heard, but it wasn't telling them what they heard, and their statements were consistent. So I think that's why we didn't see objections from the defense. I think the defense will wait until it's a thing, and we'll see how that goes. But so far, pretty limited on the objection front. So chat, we are going to go 1 and 2 with music. Let's see. We've got some options. We can hit it with kind of our standard, but that's 1. We can also do 2. We do both of these. You guys can pick 1 or 2 in the chat. And as we're wrapping up, we will pick one of the musics and we will let it roll for the day. I'm seeing lots of 2s in the chat already. 2s. Okay, perfect. We'll leave it on 2. We'll do 1 tomorrow. How about that? We'll do 2 today. We did 1 yesterday. So that's fair. And we have some new assets. So we'll be back. Court's on break. Get the Law Nerd app. We're going to let the music roll. I will turn the music down when I am back. And we will send you a notification in the app when I am back. So Law Nerds, it is break. Get some lunch. Hey, Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey, Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey, Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. It's time to get back to court. I appreciate y'all for waiting. I thank you. We had to finish up a meeting that has been on the books for quite a while. So sometimes there is nothing one can do. It's going to happen. So welcome back. We're going to get right into court after lunch, and we're giving ourselves a little bit of zoom room. I anticipate we will catch up to live feed. You guys are going to see me eating. Did I get to eat lunch? No, meetings. So I have been talking and not eating. So I also have my lunch. So we're going to get into our next witnesses. I'm just going to make sure our audio is good and everything's ready to be pulled up. And we are going to off and away to court. I hope you had a good lunch and a good break. And let's see, we are making sure we still have closed captions prioritized because, there are times, especially when I am chatting, that it's helpful to also have the closed captioning. Law Nerds, let's go.
Bring the jury.
We're going to bring the jury. Music to my ears. I did have a snackless meeting because I was doing so much talk. We were doing so much talking. So it was not as much time for the snackies. White asked, are we growing out the purple? No, I've just been unable to go and refresh. So it's just been busy. And the ends are much more purple, but they end up being on the top. So not intentionally, but like life. I'm also on a whole journey to figure out what my hair wants to do at this phase of my life. And so not dyeing it has actually allowed me to kind of figure out where my natural curl is in my hair. And that's been really cool too. All right, y'all, let's get us into court. We are using the LNC feed for now because, well, the closed captionings have been on point, and we're going to go back to court. Let's pray for good audio, shall we? Emily, there's no court audio. I know it's too early. We said zoom room. I wanted zoom room. I am sure Sarah Boone had a peanut butter sandwich and an apple and some cookies for lunch, but lots of notes. She genuinely seems happy with her legal team, or at least the amount of legal team. She generally seems to be pleased with the amount of people on her team and working with her. I think that that is probably what she always wanted, and that's not exactly the experience that a lot of public defenders are able to give because they have too many cases and not enough hours in the day because, well, government funding is only what it is. That is not a shade to public defenders. It is a reality of the stress of the resources. All right, let's get back to court. All of the judges' law clerks behind, just wild to me. Also, all right, we're called to order. Oh, they're trying to figure out the audio for the evidence. I was like, what are they doing? What are they doing? It looks like they're trying to figure out the audio for the night. That sounded like. You guys can't hear the audio for court? No? Can't hear the court audio. Huh. Well, that's a problem. Give me one moment and see what I can do about that. That is a very big problem. Oh, that's me. Y'all, that's me. Apologies. I'm sorry. I came back from lunch too fast and into the wrong browser. Give me just a moment and I will switch over to where I'm supposed to be. That is a StreamYard issue. Court, chat, apologies, we broke it again. All right, 30 seconds. Well, probably a little longer than 30 seconds. I will be right back. No, not that music, Emily. Nope, not that one. We're going to go with that. All right. Enough technical issues. We want trial, not tech issues. Oh, day one's always an adventure. All right, that was on, well, when I went away on fall break with my kids, it all worked one way. And when I came back from fall break, it didn't. So now I'm all out of routines. So hopefully now we have court audio. It seems like we do. They are trying to figure out the volume for the 911 call. So we have Zoom room as they're trying to figure that out. It looks like they're going to be playing.
This time you're on.
Defense.
No, sir.
Okay. All right. Just in the spirit of full disclosure, there are some persons behind me to my right and my left. I run the mock trial program at Barry University School of Law here.
Oh, it's students. I love that even more than if it's research attorneys. I love it so much. Oh, Your Honor, we stand. That's so cool. So he runs the mock trial program, and those are students from his mock trial program. That is such a W and a great way to bring young lawyers into the profession and actually see where things go well and where things go wrong. That's cool because he probably sits down and chats with them afterwards. Oh, I love it.
All right. Anything else, State, we need to address?
Not this time, Your Honor.
Defense? No, sir. Okay. All right. Just in the spirit of full disclosure, there are some persons behind me to my right and my left.
That's so cool.
I run the mock trial program at Barry University School of Law here in town, and these are some of my students.
Oop, I was just moving the
This is
closed
a member of
captioning.
that program, so they're here just simply to observe.
I love
So
it.
pay no mind or attention to them. With that, are we ready to bring in our jury?
Yes, Your Honor.
As a
All right, let's
research
stand and bring in
attorney,
our panel.
at points, there were times I would sit next to the judge on the bench, depending on which judge I worked with. There were times I would just be back in an office working. There were times as a law student where I would get to go sit out with the judge. During programs, I did get to go sit out with the judge on the bench. And then there were times where, as a law student, I would go sit and observe court as well. So it was really quite a great way to learn. So I think that's fantastic. I love this judge. There are judges I am more lukewarm on. This one I very much enjoy. So sitting with the judge and then getting to talk to them afterwards is so good. It's so good. They will never learn more than by doing that. So awesome.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
I've never heard that
Don't
asked
release
that way
Thank
in
you.
court. Do you recognize our jury? No, I do not. Who are you
Members
people?
of the jury, good afternoon. I hope you enjoyed your lunch. If you could, again, by a show of hands, confirm that you complied with the court's instructions that we gave prior to the break. Record reflect all jurors' hands have been raised. With that, the state is going to continue with their evidence presentation
He would
this
be a great
afternoon.
mock trial
State,
teacher.
you may call your next witness.
State will call Brian Boone.
Oh, Miguelina, let the app know Brian Boone's taking the stand. How is everything happening today? No wonder y'all were. I saw the chat as I was on my meeting. I saw the chat being like, "Where's Emily? Where's Emily?" I get it now. Thank you, chat, for being patient. I get it. That's why they're queuing up the 911 call. Oh, this is going to be very, very, very interesting. The ex-husband. Yes, the ex-husband, the father of the child. He shows up at the house and sees what's going on with. Wait. Okay.
Yes.
He's
Sir, good afternoon. You could be seated. After seated, if you could please state and spell your name for the record.
Sir, so many
Brian
questions.
Boone, B-R-I-A-N-B-O-O-N-E.
He's
Thank you,
nervous.
sir. You may inquire.
Oh my
Good
God.
afternoon, sir.
Witness 6 is Brian Boone.
Good afternoon.
Can you tell us how it is that you know the defendant?
I'm shook.
I dated her for quite a while, and then we eventually got married.
Do you see
You
her
say
in court?
you dated her for quite a while. How long are we talking?
I met her in the late 90s, and I believe it was around 2005 when we got married.
Did you have any children as a result of your marriage with the defendant?
Yes, we
Do you
have one
see her in
son.
court?
And how old is that son?
He is currently getting ready to turn 14.
How is this the next witness?
Did
I
your
am shook.
marriage with the defendant last?
No, it did not.
The jury's already
And
figured that much out.
approximately when was it that you separated?
When did you get divorced?
Began proceedings for divorce.
Probably 2017, I'm thinking maybe.
And at that time, when was your divorce actually finalized?
Maybe it was 2016. I think the divorce was 2017, I believe.
And
He's like, time is a
after your
construct, sir.
divorce, what was
A lot has happened.
your custody arrangement with your son?
This is
that
gonna
you
be
had in
interesting.
common with the defendant?
State witness.
She was supposed to have him on Mondays and Tuesdays. I would have him Wednesday, Thursdays, and then we'd alternate Friday through Sundays every other week.
So 1 week you would have 5 days with your son, and another week she would have 5 days with him.
Correct.
And was this still the same custody arrangement in February of 2020?
Yes.
And in February of 2020, did you have, do you recall the events that occurred, I guess, first on the late evening of February 23rd,
Interesting.
2020?
On that evening?
Yes.
Well, apparently, Sarah called me at one point during the night.
Do you recall about what time?
During the night.
I think it was 11 something.
When you answered the phone, how did Sarah sound on the phone?
She sounded like she had been drinking and was pretty drunk.
Were you able
Sounds
to
like he's used to
understand
that.
what the defendant was saying?
Somewhat, but she woke me up. I had work the next day. I was asleep when she called. She's done this before, calling me late at night, and generally I kind of just try to ignore it, so I wasn't really paying attention.
Who was she living with at the time?
Jorge Torres?
When she called you late that evening, could you hear George in the background at all?
Not that I remember, no.
Did you pay much attention to this phone call?
No.
Now, the following morning,
He's like, no, this
on
happens.
February 24th, 2020, did you begin to call the defendant?
Yes, I did.
And approximately what time did you begin to call the defendant?
I think it was like 11 o'clock or something.
And why was it that you were calling her?
Well, it was going to be Monday. I had him on Sunday and dropped him off at school, and I was calling to try to find out if she was going to be actually picking him up that day.
why would you have
You
a
can hear the
question
frustration.
about whether or not she was picking him up?
She wasn't generally very good about actually getting him on the day she was supposed to.
Alcohol can be such a
So
bitch.
it was not uncommon for you to have to remind her to pick him up or to make sure that she was going to pick him up?
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
Do you remember
It sounds like that happened
what
often.
time on February 24th you actually got in touch with the defendant?
I think it was like 12:30 or something.
And when you actually got in touch with her, what did she tell you on the phone?
That George was dead, and if I would come over.
Did she say what happened to him?
I don't remember if she told me then on the phone or when I got there, but she told me they had been playing hide and seek and that she fell asleep.
What did you advise her to do?
Wild.
I told her she needed to call 911 and that I would come over as soon as I could.
And this is
Call
on
the
your
police.
First phone call here at approximately 12:30.
Yes.
On 2/24/20.
Yes.
Did she call you again while you were en route to her residence?
She did. She called to find out if I was still going to be coming over.
And when you spoke with her
This man's like,
while
leave me
you were
out
en
of
route,
it.
what, if anything, did you advise her?
I told her she needed to call 911 and told her I was.
I'm just going to take a moment to note that we are 6 witnesses in, and that is the first time anyone has said what, if anything. So you can question a whole ass witness without saying what, if anything. And to be fair, that actually is an appropriate use of what, if anything, if it must be used, because it is what did she say to you, if anything at all. That is, I will give you that what, if anything. I will give it to you. Look at that. 1. That's our first what, if anything. 6 witnesses.
On my way, but she needed to get somebody over there.
How long did it take you to arrive at her residence?
From the first phone call, or?
Yes, from the first phone.
Well, I mean, I live a minute or 2 drive away, but I had to get my puppy. We had just gotten a puppy recently. I had to get him in his crate and stuff like that and put something on because I was working from home. And total time, maybe 10 minutes.
Right. He had to take care of the puppy.
When you arrived at her apartment, tell us what she told you when you arrived.
George was dead, and I don't remember if she told me now or before that they had been playing hide and seek and she fell asleep, but I at that time told her again she needed to get 911 called to get somebody over there.
Had she called 911 at this point?
No, she had not.
He's like, I told you to call 911 10 minutes ago.
So you've advised her now 3 times to call 911.
Yes.
Did you go inside of her apartment?
I walked in the front door into the
Noped
little
the fuck
tiled area, like entranceway thing.
What, if anything, did you observe?
Oh, sir, let's not make it a habit.
Made it to that point.
Looking into the living room, I could see like the end of his feet and maybe a little bit of some legs that were kind of coming out around the backside of the kitchen area.
Did you continue to go into the apartment?
No.
Where did you go?
Sarah told me she was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her. And I told her that I didn't really feel comfortable being inside. And I went out front and got in my car and waited for people to show up.
He noped out.
Did you witness the defendant call 911?
I think I was in there when she dialed it and first got somebody on the phone, but I wasn't there for the whole conversation. No, I was outside.
Did you stay there at the scene while police arrived?
Yes, I was there. I was part of it. I knew I'd have to talk to somebody, so
He's like, I'm in this shit now.
Talk with law enforcement?
I did.
Your Honor, I have no further questions at this time.
Thank you. Any cross-examination?
Judge, we want to reserve our questions for when we call him in our case.
Okay.
Okay.
All right, sir, you're subject to recall.
Okay.
Thank you.
So the defense is going to call him during their case.
Just as long as he remains under subpoena.
No
Understanding
cross.
he's subject to recall.
So somebody will contact me about when I come back?
Yes, sir.
All right, thank you.
Thank you, sir.
So the defense is going to call him during their case. Okay. He was like, yep, nope, get me out. That
State,
was
you may
much
call your
faster
next
than I thought it
witness.
would be.
Your Honor, may we approach a moment?
Yes.
All right, we're going to zoom past that. That was way faster than I thought it was going to be. You told her to call 911 3 times. It took you 10 minutes from the time she called you to the time she got over there. Okay. You saw George. You said, nope, I'm not going to be in there. Done, done, and done. All right, let's zoom while they're at sidebar.
Few moments while members of the jury, we'd appreciate your patience for a few moments while the state attaches a Bluetooth speaker so that they may publish some evidence that's been received so far.
Okay.
Mr. J, whenever you're ready, sir.
Permission to publish 3.
They're going to
You may
just
do so.
play the 911 call then? With no witness on the stand. I've never seen it done like that. Okay. I'm assuming it's a 911 call.
It's 300 minutes. Call on Monday, February 24th, 2020.
Huh.
911, what is the location of your emergency? 4748 Frank Court, apartment 3. 4748, what's the street name? France, F-R-A-N-T-Z. And the appointment number? 3. Is this a police or medical? My boyfriend is dead. Okay, then the line for the fire
She doesn't sound hysterical. She sounds annoyed to me.
That's better. 4748 France Lane, apartment 3. France Court. France Court? Yes.
Okay, is this near Mackenzie Drive?
I don't know where that is.
Okay, okay.
It's Gilwood Park Apartment.
Okay, 4748 France, correct?
Correct.
All right, correct. Now tell me exactly what happened there.
My boyfriend and I were playing last night, and I played him in the case and we were playing. And, but kind of hide seat kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase. So I don't know what happened. I don't know what happened.
Right, okay, what's your apartment number?
3.
Apartment 3?
Yeah, it's like he had like blood coming out of his mouth, and I don't know what he had, like any response. What happened?
Right, okay, all right, okay. Listen, we're getting up to 13. All right, okay. Okay,
Now?
Okay, 40, yeah, listen, we're on our way up there. Yeah, 407-716-8684. Okay, he hanging from somewhere or what, ma'am?
No, I pulled him out of the suitcase. I tried giving him CPR.
Okay, so he was in a suitcase?
Yes, and I fell asleep.
Okay, how old is he working, ma'am? 42-year-old ma'am. All right. Okay, we're setting up on the sheriff's station over out there?
Yes, sir.
Yeah, okay. All right, listen to me. Okay, that you need to confirm this one. All right, I understand. You need to confirm this. Is he awake at all? Is he conscious at all?
No, he's purple.
Is he breathing?
No.
All right. I need you to get him on the floor, flat on his back for me, okay?
I did. I tried giving him CPR.
All right.
I tried giving him CPR.
Yeah, okay,
No, nothing happened. He's purple.
okay, listen AED is in the first end of the building. I need you to get it for me, okay?
What is
Do you have
it?
an AED, do you have an AED available?
No.
They're trying to
you
go through
right
their
by
list,
him
and
now?
she's like, he's purple.
I'm sorry?
Are you right by him now?
Yes.
Okay, okay, ma'am, listen, so this is AED cold and stiff?
Yes.
Is it cold and
Well,
stiff?
it's not necessarily cold, but it's stiff.
Right, okay. All right, listen to me. Listen to me. I want you to lay flat and back from me on the floor.
I did.
Removing the pillows, okay?
Yes, I did.
All right, okay. Wait.
Stiff and purple.
Stop talking over
Right,
him.
okay, listen. Okay, man, that's fine. We're still going to put compression to him, okay? All right? Take the heel of your hand on his breastbone, right in center of the chest, right between the nipples.
Yes.
Put your hands up on that hand.
Ready, I'm telling you. Just like that, you can tell.
She's like, I'm not doing this. He's
Okay.
Please. Okay, just girdle.
Okay. Listen to me. All right, I want you to place the heel of your hand. Okay, right between his chest, right between his breastbones. Put your other hand up on that hand. We want to pump his chest to be hard and fast. Going to do it twice per second.
I'm doing it again.
Okay, no, just keep on pumping. That's all you need to do for me. Keep on pumping his chest for me. I don't need you to stop and talk or anything. I just want you to count out loud for me, okay?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. But this is 19.
Okay, man, just keep on pumping his chest. That's all you need
She's
to
like,
do
why
for
am I
me,
doing
okay?
this?
Yes. Come on, please, hurry up.
Okay, ma'am, they're driving here as fast as they can. Okay, don't stop to say hurry up. Just keep on pumping and counting.
I'm still doing it while I'm talking to you, okay?
Okay.
Still doing it.
All right, just keep pumping his chest. Count out, I'll take a count with you.
Chad, I agree with you. It sounds like she's just counting.
3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26,
911 operator's doing his job.
28, 29, 30, 31, 32. Please hurry.
Okay, man, they're getting here as fast as they can, okay?
He's stiff and he's purple.
Okay. Keep pumping his chest for me, ma'am.
I'm still doing it, okay? Still doing it. Just don't make it concept.
Right, okay, that's fine. You did a good job. Just keep on doing it for me. That's all right. They're getting there as fast as they can, along with the sheriff's office also, okay?
Please.
Keep on pumping, man. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3,
He's like,
4.
do it with
Keep
me.
on pumping for me, man.
I'm doing it. Believe me, I'm doing it, okay? We're going to play speed.
So, all right, I understand. All right, just keep on pumping for me, okay? Okay.
Please hurry.
Right, okay.
Horrible. This is horrific. What happened? Like, what happened?
Okay, man, keep on pumping the chest for me, okay? They're in the parking lot. They should be up there shortly, okay?
I'm still doing it, okay?
All right, okay, good.
Ma'am, you would be out of breath by now if you were actually doing chest compressions.
Yes. We were playing hide and seek last night.
But I also understand. She's like, he's purple and stiff.
I think they're here.
Right, just keep on pumping the chest until they push over, okay?
I am.
Okay.
I am.
Okay.
I am.
Okay.
Open. Come in. There's nothing now.
Let that take over for you, okay? And so we're there, obviously.
All right. That's my boyfriend. Is your boyfriend? Okay. Is there any kind of medical? No, not medical. Hello?
Hey, man, is this time I'm going to take your unit, okay? Yeah, so we'll see you there.
All right. Oh, man, is still there? Hello? Contact 407-716-8684, residential mobile.
That's painfully loud. Trying to turn it down a little bit.
To an automatic voice message system 4.
It sounds like she hung up. Yeah, it sounds like she hung up. And they couldn't get, when they called back, it went to voicemail.
We're ready to continue with the presentation of witnesses.
Yes, sir. You may call your next witness.
Say you call Abraham Moreno.
Okay, so that's the 911 call. That was odd. It's also a different way to present evidence. Generally, though, you put the detective up on the stand and they go through you play the 911 call. This is a different way to present evidence. Not wrong, just different than what I am used to. I actually kind of like that they're just we're just gonna play the 911 call. Y'all can hear it. It speaks for itself. It's incredibly neutral, which I appreciate.
Sir, good afternoon. Could you state and spell your name for the record for us?
Abraham, A-B-R-A-H-A-M. Last name is Moreno, M-O-R-E-N-O.
Thank you, sir. You may be seated. Mr. Castro, you may inquire.
Hey, I appreciate that.
Good afternoon, sir.
Good afternoon.
Tell us, what do you do for a living?
I'm a maintenance supervisor for apartment complexes.
Is that what your position was back in February of 2020?
Yes, it was.
And what apartment complex?
Tealwood Park Apartments.
And how long did you work for Tealwood Park Apartments?
About 2 years.
And tell us, what were some of your duties in your position there with Tealwood Park?
Daily, I cleaned the grounds, walked the property, answered maintenance calls, did emergencies, dealt with vendors.
Did you become familiar with the residents there at the apartment complex?
Yes.
Did you have occasion to meet the defendant in this case and also a Jorge Torres?
Yes.
They say the defendant in this case. They never point and identify
Turn your
her.
attention to February 24th of 2020. Do you recall that date?
Yes.
And on that date, did you have occasion to come in contact with the defendant in this case?
Yes, I did.
And tell us, what was the circumstances in which you came into contact with her on February 24th, 2020?
I was called by the manager and the assistant manager to come to her unit. I believe she was already sitting outside at that time.
And when she was sitting outside of her unit, what, if anything, did you observe about her and about the unit?
The police was there. Her ex-husband was present. She was sitting outside.
He knew the ex-husband.
And that's when she decided she wanted to talk to me and the managers.
And what did she tell you?
That she's confused. She's not exactly sure what happened. She pointed out that she recalls that they were playing a game of hide and seek. There was an instance where you were going to teach him a lesson, and then she just doesn't recall anything else until the next morning.
Did she say she fell asleep?
Yes, she did.
Did she say things got out of hand?
Fleeting.
I don't really recall that part, but I do recall her stating that they were playing their game and that George went into a suitcase and and I didn't ask any questions. I just let her talk for herself
Could we go back to she was going to teach
How
him a
long was
lesson?
this conversation?
for about 4 or 5 minutes.
Your Honor, I have no further questions at this time.
Any cross-examination?
Yes, sir.
You may inquire, sir.
We go back to the she wanted to teach him a lesson part.
Good afternoon, sir.
Good afternoon.
This conversation that you had with Miss Boone,
Yes.
that took place on the 24th? Is that correct?
Yes.
And who else was present on the time that the conversation was taking place?
Standing right next to me would have been Melissa Sexton and Eugene Harris, as well as the officer who was in front of the door.
Okay. So there was a law enforcement officer there that day, is that correct?
Yes.
All right.
I like this witness too. Just direct, to the point. She just wanted to talk. I just let her talk.
Now, on the 24th is when you said that Miss Boone made this statement to you. Is that correct?
Yes.
They were playing hide and seek?
Yes.
And what else did she say happened?
She had told me that they were playing hide and seek, they had drank, she was trying to teach him a lesson, and
What is
that was
what?
that. She went upstairs, she went to sleep, she woke up, she doesn't know what happened.
Okay. So that was on the 24th.
Yes.
All right, on the 26th, were you not interviewed by law enforcement?
Yes.
Okay. So
I may have my days wrong, but it all happened on the same day.
All right, the 24th, do you remember 2 days later that a Detective Scott Lowen conducted an interview with you at 4704 Lucier Court, Winter Park, Florida? You remember that interview?
Yes.
So that was 2 days later, is that correct?
I would assume so.
Yes.
He's like, if you say so.
All right, so when he interviewed you 2 days later, did you tell him about this statement that Miss Boone made to you that you just told this jury in court?
I did mention it to him.
You did mention it to him?
I mentioned to them that we did have a conversation.
Did you tell him the content of the conversation?
I may not have told him the whole content, but I did tell him we had a
He's
conversation.
like, we talked.
All right, well, what did you tell him, what content did you tell him on the 26th?
That they were playing hide and seek, that she was confused, she doesn't know what happened. I do believe I did mention to him the fact that she had said that she was trying to teach him a lesson. Not that anything was done with malice. I didn't state that at all.
So
He's trying to
it's
figure out
your
where the fence is
recollection now today that on the 26th, you told Officer Lowen
He said he might have.
what you just told this jury. Is that correct?
Yeah.
All right. Sir, in preparing for this case, did you have a meeting with the Assistant State Attorney on September 23rd of 2024?
Probably.
Did I have a meeting?
Yes.
A brief chit chat over the phone.
A brief chit chat that was over the phone?
Yes, sir.
All right. At that point in time over the phone, did you tell him
Colleen, that's a great question in your super chat. We'll do it when we get to
tell
a
him
break.
that Sarah Boone, the
There's a
defendant,
reason.
stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
Yes.
Is that what you told him?
Yes.
Okay. And that was in 2024 of September the 23rd of this year, 2024. Is that correct?
Yes.
Are you telling us that back on
He's like,
February the
dude, what?
26th of 2020, you told Officer Lowen at that time the same thing?
As I recall, yes.
He's like, yeah, that's what I remember saying. Do you want to keep asking me? Because I'm going to keep telling you.
So did she ever tell you how things got out of hand?
No.
Sir, you testified that you knew both Mr. Torres and Miss Boone, is that correct?
Yes.
You actually knew George Torres from a different time, didn't you?
Yes, I did.
When did you first know George Torres?
In the 1990s.
In the 1990s?
He was a teenager and he lived down the street from me and my wife.
So you had had a previous relationship with Mr. Torres?
How were you
No, not
married
at
in the
all.
90s, sir? You are young.
You just knew him from then?
Yes, as I stated, he was a teenager
He knows him from the neighborhood.
and I was an adult.
Okay. During this time, though, that you became reacquainted with him, did y'all
Chad, I
establish
agree.
a
He has not
friendship
aged
at
at
that
all.
time here in Orlando?
Get it, sir?
I wouldn't say a friendship, but an acquaintance, yes.
Okay.
He's like, in the 90s, he was a teen and I was an adult. I'm like, how though? Sorry if my cheese is loud. I have Halloween themed bagel cheeses today. This is probably going to be one of my
Sir, on
go-to trial snacks.
Monday,
Oh, it's a vampire!
February the
It's on
24th.
theme! Ah,
that would have been
win.
the day that you were with Miss Sexton
Win.
and Gene Harris
Yes,
out in front of the apartment.
correct.
Did you talk to law enforcement that day?
No,
You did not talk to him that day?
I don't recall talking to him that day, no.
Okay.
All right.
Thank you, sir. I don't have any, if I can confer.
You can, sir.
He's conferring with counsel.
Thank you, sir. I don't have any further questions.
Any redirect examination?
Just brief.
All right, thank you.
Back in the 90s, when you had previously
I'm sorry. I'm so old that back in the 90s is just fucking sending me. Maybe it's because it's day one of trial, but they're like, back in the 90s. I'm like, yeah. When music was good and we wore flannel and docs, like back in the 90s. And now we're kind of back in the 90s. Style's coming back. Like, I'm ready for it. As long as we're not running through the 90s, I'm good. I'm like, back in the 90s. But then again, we just had witnesses that were like, I'm sorry, sir. I was 9 in 2009. Damn. Sending me.
George Torres, in this case, where were you living at that time?
I lived across the street. I lived on
He's
one
like,
block.
I knew
he
him from
lived
the block.
The next block over down in the middle.
In what city?
Philadelphia, Pennsylvania.
And when
They
did
knew
you
each
move
other from Philly in the
Pennsylvania?
90s?
2018, I believe.
So in the intervening years, from your move from Philadelphia to coming to work at Tealwood Park, did you have any contact with George Torres?
No, as a
Smart
matter of
fan,
fact, I'm from that particular block in
10.
2005, so I don't meet Judge again until I work at Tealwood's.
That's a wild
When did you start
coincidence.
working at Tealwood's?
2018, 2019, roughly there.
No further questions.
Wild
Can this witness
coincidence.
be released?
No, Your Honor, just subject to recall.
Oh,
All
why
right,
do you
sir.
want
You'll be
everybody
released
subject to recall?
recall. Thank you.
Thank you.
That's a wild coincidence that he knows George Torres from the block in Philly. And for all of you that were like, in
State,
West
call your next
Philadelphia,
witness.
born
State
and
will call
raised.
Deputy Kayla Rodriguez.
Love it. I can't believe he then gets to Florida and ends up being the apartment manager at George's apartment. That must be kind of surreal and heartbreaking for him with everything that has happened in this case. It must be incredibly surreal, which can also explain why he was just like, "Argh." Murder Mittens, I also graduated in 1996. But what a small world.
Good afternoon, ma'am. You could be seated. Please state your name and spell it for the record if you could for us.
Kayla Rodriguez. Kayla, Kayla. Rodriguez, Rodriguez.
All right, thank you. Mr. Cacciatore, you may inquire.
Good afternoon, ma'am.
Hi.
Can you tell us who is did you work for?
Orange County Sheriff's Office.
And what
It's
is your
not
position
clear.
with the Orange County Sheriff's Office?
Deputy Sheriff.
And how long have you been a deputy sheriff?
A little over 8 years, since 2016.
And tell us, what are your duties as a deputy sheriff?
As a deputy, I respond to
State
calls for
witness number
service, anything from a over with call, like a car being keyed the day prior, or a 911
Do you see how
emergency.
naturally she just turned to the jury and was
what
like,
type
this is
of
what I do for a
training
living?
do you need to be a deputy sheriff?
So for me, I obtained my bachelor's degree from UCF in criminal justice in 2014. After that, in 2016, I was hired by the sheriff's office. Right after being hired, I went straight into the academy. The academy is 5 months of training. We go over everything from case law, scenarios, defensive tactics, physical training. After that, I do 2 more months with the sheriff's office where we go specifically into policy related to Orange County specifically. After that, I do 3 months on the road with a trainer where we are evaluated periodically through that process. You have a partner, you respond to calls for service during that time, and you slowly learn how to handle calls by yourself.
Do you also undergo continuing training as a condition of your employment?
Yes.
Tell us, were you working on February 24th, 2020?
Yes.
And tell us, what area of the county were you working in?
Orange County, unincorporated Orange County.
And did you receive a call in regards to this case?
Yes.
And what was that call? What information did you have at the time you received the call?
So the dispatcher informed me that a woman called 911. She was actively performing CPR and that her boyfriend was in a suitcase.
And
That's a
did you
weird call to
respond
get at
out to
work.
the scene?
Yes.
And when you responded out to the scene, were you dressed similarly as you are dressed today?
Yes.
And just for the record, you have, it looks like a standard green uniform on with a tool belt, your firearm, and also
Badge.
radio, body-worn camera, badge.
Yes.
Uniform.
Tell us about your body-worn camera.
So my body camera is used to capture scenes when we arrive. So as we are conducting any sort of law enforcement action, we turn our camera on.
You can tell she's testified a lot.
Tell us, does it immediately capture sound at that point?
It does not. When we activate our camera, it goes back a minute, and the minute that it goes back to, you don't hear any audio for that first minute.
Tell us also about the capacity and the battery life of your camera as well.
So the battery will last us an entire shift typically if it's in a buffering mode. So if we're not recording, it will last the entire shift. As we record, it does drain the battery. So typically we will turn it off if we're sitting in our car for an extended period of time, if we call our supervisor, if we're talking to another deputy on the side, away from a scene, we will not have the camera recording. If it recorded throughout the entire shift, the battery would die. We would need multiple batteries.
So you actually activate the camera in order to begin recording?
Correct.
I'm interested to see what the body camera is.
Was your body camera operational on this call out?
Yes.
I saw many of you comment that the way they covered background training and experience with this sheriff's deputy was much quicker. Yes, it was. She's just like, I did this, I did this, I did this. She's also going to be testifying to her body camera. She was there that day, so it's able to be a little truncated from what we see with experts. But everything has been very direct, very clear, and very concise. The pacing of this trial has moved quickly, given how long it took to get to this point. We're going to zoom through the attorneys chatting. Oh,
Your
and they're
Honor,
done.
may I approach the
That's the video of the
witness
body-worn
which was
camera.
previously marked for identification. It states H, I, and G that have been shown to defense.
You may.
Melissa T said she is at BNA Airport. Hello, Melissa at BNA. BNA's the remodel's lovely. The trees in the
Do you
atrium. So
recognize
good.
that disc?
Yes.
Did you have an opportunity to review that disc prior to coming to court today?
Yes.
And tell us, what is that disc?
Body worn camera from the day of the incident.
From February 24, 2020?
Correct.
And is that your initials on the disc?
Yes.
And does that disc fairly and accurately represent the contents of your body-worn camera?
Yes.
Your Honor, at this time I'd like to move what's previously been marked for identification as states I into evidence.
Any objections?
No objection.
All right, what was pre-marked as I will be received into evidence without objection as states 4.
Ma'am, next I'm showing you has been marked for identification as states H. You take a look at that disc. Tell us, what is that disc?
Body-worn camera from the day of the incident.
From February 24, 2020?
Yes.
And did you have an opportunity to review that disc prior to coming to court today?
Yes.
And is that your initials on the disc?
Yes.
And does that disc fairly and accurately represent the contents of that portion of your body-worn camera from that day?
Yes.
Your Honor, at this time I'd like to move what's been marked for identification as states H into evidence.
No objection to any of those coming in.
What was pre-marked as states H will be received without objection as states 5.
And lastly, ma'am, I'm showing you what's been marked for identification as states G. Do you recognize this disc?
Yes.
And tell us, what is that disc?
Body-worn camera from the day of the incident.
From February 24, 2020?
Yes.
And you had an opportunity to review this camera prior to coming to court?
Yes.
And that's your initials on the disc?
Yes.
And it fairly and accurately represents your conduct on the body-worn camera?
Yes.
Your Honor, at this time I'd like to move what's been marked for identification as states G into evidence.
No objection.
Thank you. What was pre-marked as states G will be received without objection as state 6.
Notice they are pre-marked and they are coming in the order they were pre-marked in. I was highly critical of the judge in the Karen Reed case
In your Honor,
for
request permission to publish
fucking
case
up all the
4.
pre-marking.
You may.
Your Honor,
They're going to play the body cam footage.
Yes.
I have seen from the chat who is given heads up. I appreciate it. I have seen from the chat heads up that they briefly do show the victim in this body-worn camera. We will always note at the top when we change to things, but if you want to skip past the body-worn camera, when the lights go back up, they will be done in court, but we are live. And if that is shown briefly, then that is what's on the body cam. It's not going to be edited out while they are in court. So just thank you for the chat who has already seen the body-worn footage. I appreciate it. But the pacing in this is helpful.
You live here? Okay, I'll talk to you guys to make sure. I know, the property manager, I don't know if I should go. Tell him really quick, or just so he knows what's going on? Where's he at? He's one that way. Oh, don't worry about that, we'll take care of that for you, okay? I have a cigarette, though. Okay, wait 1 second, okay? I really need something to drink. Okay, well, I got my dog parked on the counter. Okay, that's okay. Give me 1 second.
That is their list of who showed up on scene. So she's keeping track of everyone that shows up on scene. It seems like she was the first on scene. So she's also going to check and clear the house. So knowing that the victim's in the house, he will probably be shown.
What's going on? Who is he to you? Boyfriend? Yes, because for like 3.5 years. What happened? We drank last night. Can you pass this to the around to the FBI stuff? They need to sign that for sure. No. Each of them has to. This might be a real thing. But each of them has to.
She was just trying to say what happened. And then the officer turned away, the deputy turned away.
I just got here to fill me in. No problem. Like, you know, we're putting a puzzle together, we've been doing some artwork together. You are putting a puzzle together? Yes, we have a puzzle that we started in there. Okay. We've been doing art, trying to take stuff off the wall to make new art put up there, like having a good time with one another. But we had a bottle of wine last night. Okay. So then it's like, we decided to play hide and seek, right? Okay. So he gets in the suitcase. Okay.
He gets in the suitcase.
That's my ex-husband. My former husband. He lives here with you guys? No. I called him over here. Okay, okay. I didn't know what to do. Okay. I didn't know what to do. Okay. So then he came over here. Here, let's talk in private, okay? I called you guys. The problem is I fell asleep. When did you do CPR? This morning. When I found it. Before you called? Yeah. 1 o'clock right now. I tried. I was awake, but I actually got out of the bed at like 12:30ish. So I came downstairs, and I was like, oh, he's in the suitcase still. Well, that's when I found him, and I took him out. I tried doing CPR, and then I called him, and then I called you guys. Did he be here before the fire department got here? Who? Your husband? Or your ex-husband? Okay. Where's he live at? Right on the street. Okay. So you were playing and he did some update? I did, but then I fell asleep. Okay, you're okay. I wasn't here. I'm just trying to figure out what happened. I fell asleep. So I don't know if there's something here. Like having an aneurysm or a heart attack or what? What kind of medical condition? None that I know of. None that I know of. No. All we had was a bottle of wine. Literally, just a bottle of wine. Okay. Do a ton of artwork. Then we decided to go ahead and see. That's all that happened. Okay. So I know what in there, but I don't know what happened. So how long were you doing CPR on him prior to calling 911? You tried that all morning? Yes. Okay. And then I called him while I was
What time did you start probably? You know what ballpark? Here, let me fill this deputy in, okay?
Please, ma'am, I got Pepper. I am still cutting out right now.
She's telling her, hold on 1 second. She
Ma'am, and
said,
you can't talk to him until we get down to paper, okay?
Just don't leave, okay, Brian?
Thank you, ma'am. Appreciate it.
she said to the deputy, please don't leave.
I know.
Do me a favor. Stand over here by that party. 1 second. There's a dog in there? Yeah. You want to help clear the back bedroom real quick? Just make sure there's nobody else in here? Nope, he was here with the girlfriend, and that's the girlfriend's ex-husband. He's going to see her. They were playing hide and go seek is what she said. She's been doing CPR on him all morning before calling us. Yep. So I'm going to go ahead and start making phone calls. Okay, go ahead. What do I do with this dog? Because I don't want him to mess with me. Here, come here. Oh, perfect. Okay.
There was a dog in the house, and the deputy's like, I'm trying to figure out where we move the dog.
Yes. Hey, come on, let's go.
The deputy's incredibly thoughtful.
Good boy. You thank you, brother. But just want to make sure. Okay. I'll put my four back. Touch anything.
Orange County.
There's something.
And then it looks like nobody had cleared the house yet, and she's saying, I'm just going to double check the house and make sure nobody else is in there.
We check this closet.
Before EMTs come in. Which should be done before EMTs come in, so they don't get attacked. I like this deputy's demeanor a lot, because you could see Sarah starting to ramp up, and she's like, okay, we're going to take care of it.
All right, I guess we're going to have to set up a crime scene now.
Oh, yeah. Just give us a text, okay? It's on the camera. It's on the camera. I can't move anything from out of the house. Here, I want you to sit down, because I don't want you to pass it out. This is probably a lot for you to deal with, right? I can get you some water,
really
okay?
hard.
Just, I want you not on your feet, because I don't want you to pass it out.
Pause. It's really hard because the deputy is talking to her while the deputy has her walkie-talkie, and it is a more complex scene. So people are going to be arriving. So there's a lot going on the walkie. But the deputy's demeanor has kept Sarah Boone relatively calm because she was starting to amp up a little bit. And the deputy's like, this has to be a lot for you, has just been incredibly compassionate, has taken care of the dog, and is like, this has probably been a lot for you. Just let's try to sit down and tell me what happened. So the radio is really hard, but that is body cam.
I need to find water. Okay, I'll get some for you. You try putting on it.
And then you could see the ex-husband sitting right there as the deputy turned.
Your Honor, request permission to publish States 5.
You may proceed.
All right, this is the next video. Sarah was saying she recently woke up, but she did not just wake up. So I saw the chat saying, didn't she just wake up? I mean, she said she woke up around 12:30 and then called her ex, and it took a while for them to call 911. And this is, I think, 2 o'clock at this point. I imagine this is the first body cam where it jumps back a minute and doesn't have sound for the first minute.
I'll go ahead and start making the call. Ma'am, could you go ahead and give me his last name, Torres? Spell it for me. Torres. And his first name? George, Jorge. 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 His birthday? 2/13/78. And this is the boyfriend? Yes. How long? 3.5 years. Living together that whole time? Yes. Okay. And your last name? Boone. Spell it. Boone. First name? Sarah. Sarah. First date?
10/10/77. We now know because they make her say it every time
So,
she's in court.
you got a second to kind of collect yourself. Tell it to me again. You guys were playing last night, drinking a bottle of wine.
Putting puzzles together, doing artwork.
Puzzles, artwork.
We got a bottle of wine and they decided to play hide and seek. So he
What
did,
time was that? Do you remember?
I mean, I know that I was in bed probably by like what, 12:30?
Okay.
Well, I went upstairs at least and I fell asleep. Forgetting that he was in
You
the
guys were
suitcase.
playing the hide and go seek.
Yes.
And at some point you put him in the suitcase?
No, he got in the suitcase. So he thought it'd be funny to be put in the suitcase. So I was like, okay, well, I'm going to joke with you and I'll zip you up and make him, squirm a little bit, whatever it is. But then I fell asleep.
Make them
I fell asleep.
Where was the suitcase?
Right where it is.
Right down there?
Yes.
You zipped him in there?
Yes.
Thought it would be funny a little bit?
It was. We both were laughing about it. And then I fell asleep.
Where did you fall asleep at?
Upstairs.
In your bedroom?
Yes.
Okay.
Totally forgetting that he was in the suitcase still.
Okay. And then you came back downstairs?
This morning, or this afternoon, yes, when I got up.
What time?
12:30-ish. I was awake, but I totally forgot that he was in the suitcase. He can tell you there's a lot of things that we think of jobs.
Yeah, he did tell me.
Right, all that good stuff. So I just totally
So you
forgot.
began to do CPR on him?
Yes. Yes.
About
And he
what
gurgled.
time this morning
He
did you
gurgled.
start doing that CPR?
No, it was the afternoon. It was afternoon because I was awake. But then I finally started to come downstairs at like 12:30-ish, whatever it is. And I was like, I thought that he was in the suitcase. And he wasn't moving. Nothing was happening. So I unzipped him, took him out and started doing CPR on him. He was on his way over here. I called you when he got here.
Once he got here, you called us?
Yes.
Okay.
And air was coming out and he was gurgling, but I could tell by looking at him.
But you knew how to do CPR, you were doing that on your own?
Yes.
Okay.
And then the person that was on the phone with me also, I counted with him doing
And
it.
he's got no medical, he doesn't take any medication?
I don't know. I don't know medical-wise. I know he doesn't take any medications whatsoever. The only thing, like I said, I don't know if alcohol had to do with it, but we had a bottle of wine.
Okay, all right. Here, I want you to sit back down because I don't want
Can I have one more sip of water?
Yes, go on.
Personal 29 residential audible. 132, yeah, dry.
I'll do what I can to get you a cup, because I don't want you to have to keep doing that.
I think she just turned on the hose spigot
The cups are like right there. Right here, don't talk to the ex-husband right now. I don't. Can I have a cigarette, please? Ma'am, I can't take anything out of the house. It's on the back porch. Nope, all of it, secure, okay? I'll try my best to get you what you need, okay? Maybe one of these days you pack a pack from someone, sit down and I'll try and get you what you need, okay? Just cut. Okay. I don't want you on your feet.
She's like, can you get me a cigarette? They're on the back porch. She's like, no. It's a crime scene.
Yes, you put him out the second. He came back in?
A few of you asked in the chat why Sarah Boone didn't delete the video. I don't think she knew the video was on there. I appreciate this part of the video is redacted. That's why it's blurred.
She's sitting on the curb.
So she didn't remember taking the video. That's why she didn't remove it off the phone.
Yeah. Want to talk over here?
Your Honor, request permission to publish State 6.
You may do so.
It might be the court cameras putting them out of focus. Either way, it is appreciated. Whether it's redacted by court or redacted by the court camera person. Either way, appreciated. It's appropriate. So the detectives are on scene. Body cam audio's back on.
You get enough water? No, you want to stay seated. I don't want you getting lightheaded. So remember I said the detectives were going to come out and talk to you and go from there. You know what I'm saying? They're here. They're going to ask you a few questions and then go from there, okay? All right.
All right, Sarah, my name is Chelsea. My partner Scott. It's my understanding you reside here? Okay. Is it just you? Okay. Your former husband. Okay. But you reside here with George, and then your son lives with you, or it's 50-50? Yeah. Okay. So from what has told me, she explained last night that you guys were drinking a bottle of wine, and around midnight, you decided okay. You guys decided to play hide and seek.
Well, we were playing hide and seek, and then
was your son home at the time, or okay?
No, it was Brian.
Okay.
Decided to play. We just did it like that. Like we were putting puzzles together. We were doing artwork. You can see the puzzle that we finished in there, and then the artwork, and then decided to play hide and seek. Just being stupid.
Okay.
So he decided to get in the suitcase. So I thought it would be funny to, and he was talking about it too, to get them up in there. I go upstairs and fell asleep. So this morning when I got here, I actually got up out of the bed. I thought sure he was downstairs on the laptop, really quiet. But then I came upstairs and I'm like, where is he? Like, and then that's when I found it.
Okay.
I wanted to see if we could see Sarah, but no, they're
Okay. And then you weren't sure about if you woke up this morning
It was afternoon. I mean, I was awake, but I just didn't want to come downstairs. So I just laid in bed for a little while, and then I eventually came downstairs. He about where he was, and then I was like, oh my God, he's in the suitcase still. So I pulled him out, and I ripped him out, and I started to try to make CPR for him. I called you guys, so I called Brian. Okay. And then as soon as he got here, which is 30 seconds on the road, I called you guys. Okay. The person on the phone had me do the concussion continually still and count with him until you guys showed up.
Okay. And so as part of our investigation, we obviously have to go inside the house. We have to look at things. Are you okay with us going in the house and looking at things? Okay.
It's their consent to search.
Okay.
We're gonna go look at shit now.
And forensics, so we have to have our forensics crime scene investigators come out. Are you also okay with them coming inside, taking photographs and? Okay. Okay.
She said do whatever you need to do.
George, was he diagnosed with any kind of medical history?
Not that I know of. Not that I know of. I don't know. I mean, it doesn't take drugs. I mean, we'll have you take them while we're morning here and there, but I don't know. Like,
Well, that would be my next question. So you guys don't normally drink? You just drink once in a while, or?
well, I'm gonna say like, okay, I guess normal drinking is like we will have like a glass of wine or two, like while we're cooking dinner. Sure, we'll here and we'll play a board game with him. We'll play from there. But it's not like
A couple of beers a day?
I don't understand though, like, for a little bit that we had.
He's asking about how much they're drinking.
Like, I don't know if they had a heart.
She was saying it was a little bit of that.
What happened? I don't know.
But now there's
So were you guys together all day yesterday?
oh my God, this is
Here?
killing my ears.
Like neither of you left the apartment yesterday?
We rode up to the before to get cigarettes.
Okay.
But you could walk there.
Does he have any history of masturbation troubles? I know he doesn't now, because you said he doesn't,
I
but
don't know.
as far as you've ever known him, you've never seen him.
No. I mean, he's from Philadelphia, and he grew up in Philadelphia, and then he went to Massachusetts, and then from Massachusetts he came down here. So I don't really know, like, a whole lot of, like, medical history or
How long have you guys been together?
Massachusetts is like, can you not? We have enough to deal with.
Yeah.
You've never been to the doctor or to the hospital during that time?
He and his brother got into
They're
a
asking about the victim's
really
medical
bad
history.
argument at one point.
Briefly.
He had facial reconstruction, but he has been in the hospital from that. And then I talked him into going to see like a regular physician so he could get just like a regular like checkup thing.
Yeah.
But there were no red flags.
How long ago was that?
The surgery or the doctor?
Both.
The surgery, I think, was at this point, what?
This is the facial surgery we heard about.
2 years maybe, 2.5 years. The checkup was probably a good 2 years too.
Okay.
And the suitcase is still in there?
Yeah, I'll like.
Is it normally stored down there, or did you guys travel recently?
No, he was going to start picking from donation in there, so that's why
it's out?
Yeah.
Okay, you guys didn't recently travel somewhere or anything like that?
After you zipped them up, did you move the bag around and ask them out, or you just zipped it up and walked away and asked
we're
them?
laughing about it, but I went upstairs and I fell asleep.
But what position was he in when you went in? Was he sitting on his rear end and his head up, and he just kind of goes
Okay, so like this is the suitcase. Right, this is his head, and then he's right here, and his feet were down.
So he was laying on his side?
Yeah.
He was on his side in the suitcase.
And zipped it around.
Yeah.
Closed it and zipped it.
I was not playing.
Understand this? Okay.
So, he said that I needed to tell you guys about his family. Like, who do I talk to about that?
We're gonna do that once we walk through and see. Yeah, we're gonna.
I'm just telling you, like,
It's gonna be a
I'm
while.
afraid for my life. I want you to know that. I'm afraid for my life.
I'm gonna pray for my life.
Have never liked me. I'm the blue-eyed white devil, is what they call me. So, they've never liked me. They've never taken me in. They've never accepted me. I'll put it that way.
Have you called any of them?
We talked to his daughters yesterday.
No, I mean Like, about this? Is
No.
that not- Okay.
That's
So
not-
no one's gonna know until we will be
I
making
thought she was
that
like, I'm
notification.
praying
So-
for my life.
Okay.
I'm the blue light.
They're down the road. They're going to tell me. Kids are going to tell me. They're going to tell me. This was not intentional.
Okay.
They're not going to understand that. They're not going to accept it.
We're gonna do a thorough investigation and we will definitely make sure that.
Oh, Laura, thank you.
Okay?
And my 9-year-old.
Or he's at school.
Thank you, Laura.
I know, well,
Ex-husband.
Your husband said that, your ex-husband said he made arrangements for your 9-year-old.
She's afraid of the victim's family. 10-4.
All right, we're going to go.
It is hard for me to hear, and my brain is tired. So thank you, chat, for all of you that were like, there's probably a cleaned up version of this somewhere on the internet. I'm just watching it as it comes in trial. That she's afraid of the victim's family, but the jury will have a transcript of this. So while the jury has a transcript of this, they will see what the sides have agreed on with that.
Yes, please, but can you guys so I know what's going on?
All you have to do is get their attention if you have a question, you need to talk to us. He's standing right there, she'll be right here.
So if you need help, we're
So
here.
you guys tell me, like, so you're telling me, like, you won't call whoever it is without telling me, right? I mean, I have all their phone.
We're not calling, we're not making phone calls, we're actually gonna speak to them in person. We
That'll be
are.
later on.
It'll be later.
Prior to us making the
I'm not gonna be here. They're going to tell me,
We'll address all of that, okay, before we leave.
okay? This was,
Okay? Okay.
The neighbors are walking out like, what?
Okay, sir, I know you're panicking, okay, just relax. We'll come and talk to you. We'll keep checking on you.
Yeah, you walk out and there's police everywhere and crime scene tape. It's not a good day. Okay. That's the body cam footage. And now what? You've set a fast pace. We're going to fill the silence of the pauses.
While you were at the scene, did you also make contact with Brian Boone?
Yes,
Did you take a statement from him as well?
I did.
Were all your interactions with the defendant on that day captured on your body-worn camera?
Yes.
I have no additional questions at this time.
Thank you. Any cross-examination?
No questions, Judge.
All right.
Is this witness released?
No
Yes, Your
cross.
You're released, not subject to recall, ma'am. Thank you.
Thank you.
Can the parties approach for a moment?
I want the judge to pull them up there and be like, good job, everybody. You're really crushing it. We're moving along. What's the pacing for the rest of the day, folks? Because they are moving through these witnesses pretty quickly. I appreciate the defense attorneys being like, you know what, there's no questions we need to ask. The body cam footage speaks for itself. It is what it is. You said what you said. The camera says what it is. And that's really all you need. But it looks like they're about to take a court break as I was trying to scrub forward, which gives us the opportunity to zoom and get caught up. All right.
Regularly scheduled 30. It is 3:21 at this time. We're going to go ahead and take that afternoon regularly scheduled break. I'm going to ask you to come back here in 15 minutes at 3:37. Similar instructions that I've given you previously. Please don't conduct any independent investigation or research as the person, places, things, or charge involved, and do not have any discussions amongst yourselves or anyone else. I thank you for your service, and we'll see you shortly.
Perfect. Lyndon said trial speed run. It really feels that way, doesn't it? I'm going to zoom past this and answer a few questions. And I think the 3 weeks is probably an abundance of caution for the jury. I don't think it'll take that long. Volfan, hey, why would she reject the offer? I think she thinks she's going to explain to everybody that this was an accident. That's just my perception. I think she thinks she's going to be able to say this was not my fault. Like it happened, but I didn't mean for it to happen. Oh, and we have some clarification. The judge
Y'all may
told
be
us
seated. Thank you.
all after lunch.
Bless you. State, anything else we need to address?
No, Your Honor.
Defense?
No, Your Honor.
All right, we'll be in a recess till 3:37. Thank you very much.
The judge told us all after lunch that he teaches trial advocacy, and those are some of his trial advocacy students. So that is who is sitting up at the bench with him, which was nice to know. I'm glad he put
We're
that
back
on the record.
Case number 2020 CF
All right.
2603.
After the break.
State of Florida versus Sarah Boone. Let me get appearances for the state.
Dave Kester on behalf of the state.
And we're going to get into more witnesses.
Defense?
James Owens for this. Tony Henderson for Sarah Boone. Devin Battaglia.
All right. Ms. Boone is still seated at counsel's table, wearing the same black
swoop.
suit and pink blouse from this morning.
We got stuck in a
State,
swoop
anything we need to
loop.
address
Sorry,
before we
Chad.
bring back in our panel?
Not for the state.
Defense?
No, sir.
All right, let's go ahead and stand, and we can bring back in our panel.
Was a broken swoop loop. Apologies, Chad. I promise. The first day of trial is always a little rockier. It'll get better as we go on. The jury is coming in now, so we're gonna zoom through.
Yes. Members of the jury, again, if you could please raise your hands, showing that you complied with the court's instructions during our last break. All right, the record reflect all jurors have raised their hands. State, you may call your next witness.
State will call Deputy John Martinez.
They really are speed running witnesses today. But it's nice. It's how it can go when you just need, I need this testimony from this witness. When trial lawyers are organized, you know exactly what testimony you need from each witness. You're ready to go and you're like, I need these things. I need this witness to come in and get the body cam footage in. Done. I need this witness to authenticate the receipts from the store. Done. When you are organized and you know what information you need, you look at the elements of the case and you go, I need this from these witnesses. You bring them in, you ask them that, and then you let them go. That's it.
Sir, good afternoon. Can you state and spell your name for the record for us?
This is witness number 9.
Thanks, sir. You may be seated.
9. Witness number 9. And they just started this morning.
You may inquire, sir.
Good afternoon, sir.
Good afternoon.
Tell us, who is it that you work for?
Orange County Sheriff's Office,
And what is your position with the Orange County Sheriff's Office?
Deputy Sheriff.
How long have you been with the Orange County Sheriff's Office?
I'm going on my 16th year.
Prior to working for the Orange County Sheriff's Office, do you have any previous law enforcement experience?
I do.
And where was that?
I first started my career with the New York City Police Department,
And how long were you with the New York City Police Department?
about 10 years.
And what was your position with the New York City Police Department?
I was a police officer.
And at the Sheriff's Office, tell us, what are some of your duties as a deputy sheriff?
I respond to calls of service. My primary function is the school resource officer.
And is continuing training a condition of your employment with the Sheriff's Office?
It is.
Tell us, how is it that you became involved in this case?
I was dispatched to this location.
And what was this location?
It was located at 4748 France Lane, apartment number 3.
And is that here in Orange County, Florida?
It is.
And when you responded to that location, who did you first come into contact with?
I came in contact with Miss Sarah Boone.
Do you see Sarah Boone here in court today?
Oh,
I do.
hallelujah.
Could you please point to her and identify her clothing she's wearing?
The lady sitting in the middle with the black blazer.
Your Honor, may the record reflect that the witnesses identify the defendant?
Should have happened with every single, that should have happened with every single witness. That should have happened with every single witness.
During the time that you were on the scene,
I don't think it's going to be a huge issue, but it should have happened
I
with
did.
every witness.
And was that body-worn camera
Crazy.
activated?
It was.
I'm activated at the moment.
Were all your contacts with Miss Boone recorded on that body-worn camera?
It was.
Joe Jabby's going to get an
Were other
earful of it.
deputies also on the scene?
And then they didn't identify the witnesses.
Yes.
9 witnesses
And was Deputy Rodriguez there?
She was.
So would both of your body-worn cameras both capture some of the same time frames?
Correct, yes.
Did you have an occasion to go inside of the apartment?
I did.
And inside of the apartment, what observations did you make?
When I first entered the apartment, I noticed a Hispanic male laying on his back and looks like a small nook dining area.
Hi, Judge.
Later identified Mr. Jorge Torres.
This is the first time they've identified a witness this entire trial. They've never identified the defendant. 9 witnesses. We're 9 witnesses in. 9 witnesses in. And they just identified. I had to text a Florida lawyer friend. Wait, I texted lawyer, I'm like, am I crazy? Have I slipped into a vortex where we just don't identify the defendant on the record to make sure we're all talking about the same person?
You may.
And he was like, no, they should be doing that. I'm like, am I crazy? Like, have I lost my fucking mind? No.
I'm showing you it's been marked for identification in the states.
Now we're here. Now we get into the
Do you
body-worn camera.
recognize that disc?
I do.
We're identifying
Tell us, what is that disc?
the defendant.
Is a copy of my body-worn camera.
And does this
Oh,
body-worn
it's
camera
lunchtime.
fairly and accurately depict the
Fair.
portion of the events that took place on February 24th, 2020?
It does.
And are those your initials on the disc?
Yes, they are.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states K into evidence.
Any objections? No objection. What was pre-marked as states K will be received into evidence without objection as state 7.
I like this judge so much.
Your Honor, request permission to publish.
You may. Madam Clerk, can you dim the lights?
Your Honor, this honor has his trial ad students sitting with him at the bench. It is fantastic. But yes, 9 witnesses before the prosecution went, oh yeah, do you see Sarah Boone here in court? I feel like we must be somewhere on live trending because sometimes you can just tell when we've broken on through to the other side on YouTube. But yeah, it's his students from trial ad, and I imagine he's going to say to his students on trial ad, did anyone notice that the prosecution didn't identify the defendant? They referred to her as the defendant. When did you meet the defendant? But they never said, and do you see her in court? I'll be over it in a minute. Maybe. It's just so ingrained to you as a trial lawyer that you have to ID the defendant. So, anyway. But I like this judge so much. I don't know what's on the screen. Evidence presentation, wired connection setup, central presentation devices, document center. I don't know. We're waiting for the audio to kick in. There we go. So this is going to be a different angle on the body cam. Why is there Gatorade in the bushes?
They're coming out now. I'll get you somebody, okay? She wants to say something. She wants to talk on.
For those of you who are saying it's choppy, it's body-worn footage. It's not you. It's the body-worn footage. It's choppy.
So that we will not know answer to that because we're not. So what's gonna happen is go to his office and they'll have what's called a non-cop. Yeah. That'll be first thing tomorrow morning. I'll know a lot, hopefully a lot more tomorrow morning as far as him. But I cannot, there's no way I can say how, why. So just by looking at him, like, why is he purple? That's normal when someone passes away, but then any turn.
It's so hard to stop speeding before it starts to settle. It's always intensified. And it becomes very,
They're telling her they'll know more tomorrow.
I'm like really scared. I want you guys to know that.
Well, we have all these evidence here, so about we're here, nothing's gonna happen. Before we go and make any notification, you'll have plenty of time to leave or do whatever you need to do, okay? And we can talk about that more in the time, right? That you,
But like, I don't, like, this was totally like not intentional. Like, that's what I'm scared about too. Like,
She's scared she's gonna get in trouble.
we'll have all the answers. We'll have a lot more answers tomorrow. Like you said, what you're seeing here is common. This is us coming out.
Protocol.
Yeah, it's no real medical history that
I know of.
For him to have passed away, we come out.
I know. Yeah.
We come out and do an investigation. Medical examiner's office, we send people out, this is what we do. If he was 75 years old and had a history of heart condition.
Yeah, we need to figure out what happened.
I don't know what it is.
Exactly. And that's what we're here to find out. We're just here to give you the answers. The answers that you want, the answers that his family
I just
want.
really want to see my son. I really want to see my son. I mean, I know I can't go anywhere, but it's right. So do I just like sit out here and wait for you guys?
If you would, yes, please.
Does anybody else have you to show up, or everybody's here that needs to be here?
My team's here, that needs to be here. The medical examiners will show up when we call them, but we're not ready for them yet. So they're gonna take him, they're gonna take the photos, take him, but that's sort of the end of it. And they'll be called well in advance when we're ready for them, but we're not ready for them at this point. So we won't be calling them quite yet. Okay? So like I said, I gotta go do some paperwork. I know they're gonna chat with some people, and then we're gonna come back and talk to you if you're okay
They're
with
just giving her
that.
a breakdown of what's gonna
So
happen.
just give us a little bit more time, like I said, and you go and do that.
So, like, you guys tell his family, like, today or after tomorrow?
You have to.
They're like, no, we're gonna tell his family today.
Once our investigation is pretty much complete here, once we leave here, we will be going to.
They're gonna let the victim's family know.
Go into it, but you know, you're up. Talk to you about it, anything like that.
But how, I mean, I understand what you guys and how you do it, and, you know, so, but, like, what are you just telling them? What do you tell his parents? Like, what's the reason I was away?
We tell them what we know about them.
Yeah.
We tell them the truth.
And that we're
The
gonna
detective
wait
said we tell them what we know, we tell them the truth.
I will get the autopsy in the morning, and hopefully the doctor will be able to give me some of what they think and see.
Their number, they can contact them and get it, you know.
So yeah, they're gonna know what we're here, what we're investigating, and that we're still.
They're gonna think I killed him. They always have said that. They've always have said that. I told you because I'm the blue-eyed white dragon. That's what they call me. Because they don't want him with me. So he's basically just not really been around his family because he chooses me over them. Even after I encouraged him numerous times to go there and see his family.
Oh, the wind! Why is the wind editing out what she is saying? Why can't we be great?
Do you have somewhere safe that you can go tonight?
Both my parents are deceased, my grandparents are deceased, and my aunt and uncle are deceased. I got nobody. I have a brother that's in the Marine, and I've got another one that's in jail.
I've got a brother that's a Marine, I've got one that's in jail, I've got no family, everyone's deceased. And she's talking about his family.
I think he's doing whatever he's doing. But the only way...
Your phone's inside, correct?
Yes.
Does he have a phone?
No.
He doesn't. He used my phone. He used your phone.
Yeah, the sheriff.
So the only place I could go is over to Brown's house. So I don't think I'll have a problem with it. So, well, like I said, we're not going to leave here. If you do not feel safe, you're not going to leave here. We do not feel safe. But then we're like, and then so I in Philadelphia. Well, she's in Philadelphia because there's going to be a funeral, right? That you're talking like days and.
She's trying to figure out logistics.
Right here, right now. So let me do my investigation. Let me go do this paperwork that I'm talking about because we can go back and forth about what ifs like all day long. I know. So I promise we're not going to leave here for you and you not feel safe. Okay? Please. I don't even know what to tell you. It's okay. Just take a seat, have some water. Give us a few minutes. Let us do everything, and we'll be back.
Give us a few minutes, we'll clear the crime scene, and you can go back in.
Good. Thank you. Thank you.
Yeah.
Go ahead.
Okay.
You have anyone in there?
There's nobody here, just me.
Okay, that's fine. You're right there.
Yeah.
Sit there and take your mind. I have relief coming, so just make it.
Yeah, I see a number of comments in the chat saying law enforcement has been incredibly patient with her. They have been very patient with her. They also don't know what happened. They don't know if he had a heart attack, if this was an accident. They don't know. So they're trying to figure out what happened and trying to be calm
Any
with her
cross-examination?
and figure it out.
Can this witness be released?
Yes, Sean. Yes.
Thank you, sir. You're released. Not
Look at
subject to
how
recall.
direct
Thank you.
and concise this testimony is. If we can just identify the defendant every time, I would have very few notes. So all of law enforcement showed up and was just
State,
like,
may call your next witness.
hey, we're here to do our job. We're here to figure it out. We're going to figure it out. But it's not dramatic. No cross-examination. On to the next witness. I saw a few people genuinely asking why we have subscribers only mode on. It's because as the streams get large and as the streams on live trending, it keeps down the spam because streams do get spammed in the chat and the law nerd community doesn't want to play whack-a-mole with spam. So that helps tremendously.
You state and spell your name for the record.
Keep the spam down. And that's what our community prefers.
Melissa Roughgarden.
So if you're new, welcome.
MELISSA ROUGHGARDEN.
Thank you. Counselor, you may inquire.
Ma'am, who do you work for?
I'm employed with the Orange County Sheriff's Office.
What is your position with the Orange County Sheriff's
State's witness number 10.
Currently, I am a forensic biologist with the forensics unit. Prior to this, I was a crime scene investigator for 5 years.
And
Hello,
how long in
CSI.
total have you been with the Orange County Sheriff's Office?
About 6.5 years.
Do you know anything about Troy Teskey and his
Tell us all
rounds?
the positions you've held during that time.
Those two, a crime scene investigator and a forensic biologist.
Let's turn to your work as a crime scene investigator. What does a crime scene investigator do?
We respond to crime scenes. We photograph and document those crime scenes through photographs, notes, and sometimes sketches. We collect evidence, we process the scene, and then we do further processing to that evidence back at our forensics lab.
When you say process the evidence or process the scene, can you tell us what that entails?
It depends on the scene and the evidence, but it includes the photographs. We also take swabs for potential DNA. We can also do testing for possible blood and things like that. We also process for latent fingerprints, among other things.
Just a question. How do you feel about red silver
Training
cups?
that you need in order to become
I have a question. Just how do we feel about that?
investigator?
Upon being hired with the sheriff's office,
Look how concisely
as a
they're going through background
CSI,
training
I
and
completed a
experience.
16-week training program, which includes in-house processing
heart.
as well as going out to crime scenes with trained crime scene investigators to observe and then assist, as well as taking on calls with the trained crime scene investigator.
Approximately how many crime scenes have you processed in the course of your career? In your course of
Yes, Chet, I see all of you talking about that.
It would be hundreds. I don't know the exact amount.
Were you working in this capacity as a CSI on February?
For all of you asking, was it snowing? No.
Yes, I was.
No snow in this case. I'm confident
And
there's no
tell us,
snow.
where did you respond out to on that day?
I responded to 4748 Franz Court, apartment 3.
And is that in Orange County, Florida?
Yes, it is.
He's doing so
And
well with the
when you
jurisdiction.
responded to that
He
scene,
asks everyone the
who did you
jurisdiction,
make contact with?
but he doesn't ID the
I made
defendant.
contact with
I'm
the
still
homicide
mad.
detective, Chelsea Kepsel.
Did you receive information from the detective?
Yes, that it was a death investigation.
Did you walk the scene with the detective?
Yes.
And tell us, what does it mean to walk the scene with the detective in a homicide?
We go into the scene and just observe. We don't interact with anything and discuss what we see.
When you walked this scene, did you see Jorge Torres?
Yes, I did.
And where was he located?
He was located on the floor in the living room of the apartment.
Did you, with the
Thank you,
detective,
Alicia. I won't get too
identify
well, no,
official
I
items
don't
of
think there was any
evidence
snow
to
in
be
this
collected?
case on this day. I'm
Yes.
confident about that.
You had mentioned previously about documenting scenes with photographs. Was that done in this case?
Yes, it was.
Moved on from prime to Celsius at the defense table. What book is on his table? I'm curious. He's showing the defense what he is going to show to the witness. So he's like, this is what we're admitting. No surprises. Really, my only feedback is I am still so disoriented about the ID thing. And I promise I will let it go over the weekend. For all of you saying Celsius gives me the jitters, I stay away from Celsius. I do not. There's no.
Your Honor, may I approach the
It's a nope
witness
for
that's
me.
been marked for identification as states M and been shown to defense?
So this is
Ma'am, I'm showing you what's been marked for identification as states M. Can you take a look at the contents of state M to yourself and tell me if you recognize the items contained within states M?
This is very simple, kind of textbook admission of evidence. It is just a very, once you know the pattern, it's just a pattern. It's a series of questions. It's marked for identification. Can you take a look? Do you know what this is? Can you tell me what it is? And that it's just so linear, it's making my brain happy. It's just, which makes it so easy to follow. Lee said we use Celsius in South Africa. We're talking about the energy drink, though, not the what my son believes is superior method of measurement. So no, not the superior method of measurement. We are talking about the energy drink. But my son's also in like AP chemistry, and Celsius is very much his friend. So somebody's going to be watching this trial back, and I'm going to, Friendly Farm Girl, I'm going to grab that. Somebody's going to be watching this trial back and do what Kristen just said and be like, do we think EDB is going to let the lack of identification go? Someone's going to be watching this back on replay and be like,
You
no,
recognize
she
the
did
contents
not.
of states M.
Yes, I do.
Tell us, what is the contents of state M?
They are photographs I took on the crime scene.
So those are the crime
Do
scene
they
photos?
fairly and accurately represent how that crime scene appeared on February 24th, 2020?
Yes, they do.
Your Honor, at this time, I'd like to move what's previously been marked for identification. as
He
states
just
M
moves
into
evidence in
How
such
many
a linear,
photographs are there? Do you have a
clear
total?
way.
No objection. What was pre-marked as states M will be received into evidence without objection as states 8.
That's it. So marked for identification, states M is now states 8. It is the crime scene photos taken by the CSI. linear, simple questions. There are some things to law, especially to trial, that are just a
Your
formula.
Honor, request permission to publish.
It goes the same way every single time, and he is following the formula quickly and well.
Your Honor, could we have the lights dim?
Yes.
Mary asked in the chat, can the jury see the evidence that is not brought in? No. They only see the things that have been properly authenticated and moved into evidence. Notice they cannot publish to the jury until you go through this whole process. So they went through the whole process of authentication. They moved it into evidence from being marked to being an exhibit, marked as an identification to an exhibit. Once it becomes an exhibit, then it can be published to the jury. Before that, it cannot be published to the jury and they can't see it. So there are things that might be pre-marked that do not become exhibits, that do not get introduced, or that there's not foundation for, and they don't get to see that. They only get to see what is properly introduced into evidence, and that is a protection against improper evidence and violations against the Constitution and such. There are rules. He is showing her a picture, I just don't know which.
Tell us, what is this?
This is the front door to the residence.
Easy. I'm showing you this picture, what is it? I'm showing you this picture, what is it? What about this one? Oh, thank you, Octo. Octo said we're approaching 800,000 subs. Yay!
Stage 5.
What is this? The front entrance.
This is also the front door of the residence, just a closer image to the door.
Kit said, wonder who, if anyone, is for trying to trick Lally into watching this trial with a speaker repeating, see, Mr. Lally, so succinct,
When you enter
so
the
concise.
residence,
Very
what
demure.
is the first
Just ask a
area,
direct question.
Just off to the right of the front door.
That would be the kitchen.
Showing you it's been marked as states.
Heather in the chat asked if the large
Yes, so
box in
this-
support was the suitcase. I think so. They're not
This
going to
is
show
just
some of these
inside the door.
photos.
To the right, there is the kitchen area.
They're going to be careful about showing some of these in case the victim is visible. I appreciate the conscientiousness of the in-court camera operator for that. So,
Showing you states 14.
Yes.
What is this a photo of?
So this is the counter with the sink in the kitchen, and there's also the open area just above where you can see into the living room.
Showing you from states composite photo 19.
Yes.
What is this?
This is a hutch inside the kitchen. You can see in the background, that is where that first photo of the kitchen was taken. So that's the entryway. And then this is the hutch, and there is a cell phone on the hutch in the kitchen.
so they photographed it because that's where they're recovering the cell phone from. Tina's asked, didn't she get 5 years and has already served 3? Not in this case. The state had offered her 15. She has been in for over 4. She rejected that offer.
This is the
Trial.
trash can in the kitchen. You can also see the hutch we were just looking at there on the side.
I really appreciate how this CSI is like, see, this is how you know where we're oriented. So orienting back to the pictures, not every witness does that well.
This is the contents of the trash can. You can see 2 wine bottles on the top of the trash.
Ma'am, those are mega pints
You
of
also
wine.
find receipts in that trash can as well?
Yes.
The receipts.
Photo 25 from the composite.
These are those same wine bottles and 3 Publix receipts that were removed from the trash can.
Did you take these items and collect them into evidence in this case?
Yes, I did.
That's true. I've not heard the CSI say the crime scene talked to her. Doctor Who 8675309 said, do we know if the crime scene talked to her? If y'all didn't watch some of the Karen Reed trial, that was actual testimony. I'm not joking. I wish I was. I'm going to pull up some super chats as they're going through these crime scene photos, and there are quiet moments.
This is just in further into that entryway. You can see the living room.
Trina asked a question and said, is it normal for the defense to sit close to jurors? No, in a lot of jurisdictions, the prosecution sits closest to the jury box, not the defense. So it varies by jurisdiction. So it seems like it's normal for this
This is
courthouse.
another photo of the living room. You can see the victim located on the floor and a suitcase in the bottom corner of the photograph.
Again, whoever's running the pool cameras for this trial, well done. Neen said, I like this short and sweet testimonies. Sometimes there's just not more you need. If you're organized, you know what you need. It's like going to the store with a list versus going to the store without a list. You go to the store without a list.
This is
it's gonna be a
another
disaster.
photograph in the living room. This is that wall we saw in the kitchen there with the opening. You can also see a wooden baseball bat leaning against the wall.
Was that baseball bat collected into evidence in this case?
The baseball bat
Yes, it was.
leaning against the wall near the victim.
Photo 38.
This is, excuse me. This is also a photograph of the living room, just the other side of the room.
Photo 43 from the composite.
Yes. This photograph was taken in the living room. You can see the stairs leading to the second floor.
There's not a lot of room at the end of those stairs. Yes, the chat's ears are still not over the weeks of repetitive testimony in the Karen Reed case.
45.
This is a photograph of the living room just from the other side of the room. You can see the front door in the middle back of the photo.
All right, I'm going to pull up some of our chats while we're doing this.
Photo 49 from the composite.
There's some really good questions.
This is a more close-up photograph of the suitcase.
Well, and Ralph, that's a lot of degrees. 1 law degree and 2 PhD library science. However, law librarians are super helpful.
This is a photograph of one of the zippers on the suitcase.
It's a broken zipper. Like it doesn't have the pull tab at the top.
Photograph 51.
This is a close-up picture of that same zipper. There is no zipper pull on it. It appeared to be a small wire of some sort, the pink wrapped around
On the zipper
the
pull.
zipper.
Is it like a paper clip or something?
This is the zipper on the other side of the suitcase.
They're both broken.
Just for the record, that's photograph 52.
Looks like both the zipper pulls are broken.
composite?
The close-up image of that same zipper, there was also no zipper pull on that one.
Is there an internal zipper as well?
Photo 54 from the composite.
This is the contents of the suitcase after just lifting the lid.
It looked like there was stuff in the suit, like clothes in the suitcase.
Photo 56 from the composite.
More of a close-up image of the items. There were miscellaneous papers and paperwork, some clothing items, and apparent blood inside the suitcase.
What items, what apparent blood was inside the suitcase?
It was observed on the white cap and a necktie, and there was also visible blood just on the interior of the suitcase.
Photo 57 from the composite.
The contents of the suitcase, but you can see the white cap more clearly and the blood observed on it.
And she did talk about that when in the police interviews, that there was blood on his mouth. We also know that there is
58 from the composite.
You can see
bleeding
the
and bruising
necktie
from
with
the
blood.
autopsy from
It appeared
opening.
to be silver multicolored. And then there's also a diazepam syringe in the plastic casing there. It was prescribed to the victim.
Photo 61 from the composite.
That is the miscellaneous papers and paperwork that was removed from the suitcase.
Photo 62 from the composite.
That's the suitcase after all of the items were removed.
I assume that's what's in the box in court.
Photo 64 from the composite.
Yes, that is what appeared to be some like small pieces of paper that appeared to be soaked with blood.
Is this inside of the suitcase?
Yes.
Photo 65 from the composite.
That is the baseball bat that was leaning against the wall in the living room.
They'll probably bring that into court, I
Photo
imagine.
68 from the composite.
This is back to the stairs to the second floor in the living room.
Yeah, with the bookcase at the end of this, there's not a lot of room at the end of those stairs.
Photo 69 from the composite.
So it's moving closer to the stairs to the second floor.
Photo 70 from the composite.
Photographing more of the staircase. These are the steps leading to the second floor before I proceed up to the second floor.
This is photo 71 for the record. Photo 72 from the composite.
The upper portion of the stairs leading to the second floor.
And this is just the layout of the house.
How many bedrooms were on the second floor of the unit?
There were 2 bedrooms.
photo 75 from the composite. What is this?
This is the hallway. You can see a closet in the hallway and then the door to one of the bedrooms.
This appears to be a child's room.
Yes, it did.
Photo 79 from the composite.
This is a photograph within the child's bedroom.
We don't know the victim's toxicology yet, and most of the victim's medical history won't come in. If we knew more, it would have been at this point from the defendant talking to law enforcement. We'll see what comes in at trial. It's why I don't speculate on it. We will know what we will know.
This is the door leading to the other bedroom upstairs.
And we will hear from the coroner next week.
Did this other bedroom also contain a bathroom?
Yes, it did.
For those of you asking, the defendant's child was with his father.
This is
night.
the bed within that bedroom.
And I imagine the rest of the day is going to be doing this. Crime scene photos have to come in. It is not always riveting, it's needed, but it's just going through the evidence. And I just put a Hershey's Kiss in my mouth,
Photo
but
97
we had a moment to do super chats. I'm going to try to do that. The bathroom.
This is the bathroom.
in that master bedroom upstairs?
Yes.
Did you also have an occasion to photograph the defendant?
Yes, I did.
You see the defendant here in court today.
Yes, I do.
Look at that.
Could you please point to them and identify our article of clothing?
Somebody said, hey, buddy. Hey, bring it in. You've got to ID the defendant in court. You've got to ID the defendant in court. The judge IDing the defendant in court for the record and for the appellate record that she is present is not the same as the witnesses IDing the defendant in court, saying the Sarah that we're talking about is the Sarah that is sitting right there. Same. It's just like, you've got to verify what Emily you are when you go to Starbucks to pick up the order for Emily, because sometimes it's a strawberry lemonade refresher, which is definitely not what I ordered. So, if I want my pumpkin cream cold brew, a refresher is very much not the same. So you have to verify that the person we're talking about is the person we're talking about. So somebody mentioned to him that this needed to be done, and now it is happening. So let us continue.
She is right there.
That's
with
how that is
a
normally
black
done.
Blazer and a pink shirt.
Sitting right there.
May the record reflect that the witnesses identified the defendant?
Record so reflect.
Finally. Glad we're back to there. Normal trial.
Showing you photo 98 from the composite.
This is the photograph I took of the defendant.
Why is it that you are photographing the defendant?
To see if she had any injuries.
I collected her buccal swabs, which is a
DNA.
DNA standard from the inside of the mouth, and it is part of our procedure to photograph that person for identification purposes.
That's also helpful. She also has no visible injuries, which is also helpful. But she didn't say anything where she would necessarily be photographed for
You also
injuries, but it is
document
helpful.
The rest of her body as well at that time.
Yes, I did.
Publishing photograph 101 from State's Composite.
Yes, I've changed my Starbucks name, so
This is a photograph
other
of
Emily can
her hands
enjoy
facing
her
upward.
order. I can enjoy my order. Everything is good.
Photograph 102.
This is her right hand facing upward.
Photograph 103.
Her left hand facing upward.
Photograph 104.
Both of her hands facing
Just-
downward, so the tops of her hands.
So we know.
Photograph 105.
This is her right hand facing downward.
Photograph 106.
And her left hand facing downward.
Photograph 107.
These are all the photos of the defendant,
This would be of her right arm.
which will come into play more, I imagine.
Photograph 108.
Her left arm.
Photograph 109.
Her right arm with it facing upward.
So it's all the photos of the defendant.
Photograph.
I'm going to go through some of our super chats as we're
Her
doing
left
this.
arm with her arm facing upward.
During the time you were
Lauren,
interacting with the defendant,
I will be there
did
too.
she ever indicate to you that she had any injuries?
No.
Did the defendant have any injuries? No. But we knew that. It is not an issue. Colleen, thank you for the gifted memberships.
You had previously testified that you also collected physical items of evidence from the home as well, in this case.
Yes, I did.
The teaching life,
Honor,
I'm
may I
so
approach the
sorry for
witness
that
with
experience, but
remark
yes,
that
the
patient
stress
has
is
stayed
very,
seated
very
and shown
real.
to defense.
You may.
He's approaching with the other items that are being collected. I think we're going to probably go through all of the physical items of evidence in the room as well, including the big box with the suitcase in it.
Ma'am, I'm suing you with remark for identification as state C. Can you take a look at that package for me?
Yes.
Do you recognize that package?
Yes, I do.
Thank you, Lauren.
And tell us, what is that package?
These are the 2 wine bottles that were collected from the trash can.
Is your name on that package?
Yes, my name is on the Orange County Sheriff's Office evidence label that I filled out, and my initials are on the evidence seal from when I sealed the package.
Evidence seal,
And it also has your
ma'am.
agency case number.
You spoil
and,
us.
The location information.
And a case number and a
Yes,
signature.
that is correct.
Spoiled.
Ma'am,
We're
could you
spoiled.
open the contents of state
And it's
C
sealed?
and look at it
Ma'am.
to yourself?
Look at the chain of custody. Look at how much writing is on that bag. Look at and the gloves. Wow. A normal trial. Look at the evidence tape. So good to see. So good to see. Did you see how much writing was on that evidence bag? That is what I expect to see on evidence bags. A full chain of custody and tape. Look at that. We're back to like how it's done. Other than the identification, which I will get over eventually, maybe, because ADHD. The way that evidence has been admitted is succinct and linear. You know why? Because the case is what it is. The defendant did what she did. She said what she said. She videoed what she videoed. That's it. They need these witnesses to come in and say, this is the thing. This is the thing. That's it. Linear and succinct because the evidence stands on its own. It's not confusing. You just go, proceed ahead. Actually, Ashley shared something with us in the chat and said, Emily, I'm listening as I am at the Arby's drive-thru. The person giving me my food said, "Is that EDB?" I am a law nerd. Law nerds in the wild. Love it. Love to see it. I hope you guys both had a little bit of a smile. I appreciate it. Thank you, Casey Cat. You've gifted so many memberships today. You guys are incredibly generous, law nerds. You are the best. So thank you. I'm going to try to answer some questions while she's opening all of the bubble wrap. Look, all of the glasses bubble wrapped, right?
What is the context of state sick?
These are the 2 wine bottles that I collected from the trash can.
Love it.
Are these wine bottles in the same or substantially the same condition as they were at the time that you packaged them on February 24th, 2020?
Yes, the same time I collected them that day.
It's like it
Your
looks
Honor,
the
this
same.
time I'd like to move what's previously been marked for identification as states C into evidence.
Any objections?
No objection.
What
And
was
there it is.
pre-marked as state C will be received into evidence
Now
as
it's
states
being
9
received
without
as
objection.
evidence, and then it can be shown to the jury. Now that it's been received as
Your
evidence.
Honor, request permission to publish.
You may do so.
Look at how smooth. Look at how linear. Ugh. I just feel calmer when I know everybody's handling their shit. It just makes me calm. Confidence is just so delightful like that. You're just like, everything feels normal. The reason it's important to bring things in physically is, one, you never know what photos are going to do. And actually being able to see the physical thing when it matters, like the size of a bottle of wine, because it is a large bottle of wine, matters, because intoxication is very much at play here. And then she's putting them back in the bubble wrap so you can go back to the court. So seeing them in person helps. Sometimes things look bigger or smaller in photographs, which is why you should never, ever DM photographs. Everything looks smaller. Don't DM photos. Everything looks smaller in photos. Except when people take them of me from down below, then much larger. Hate it. But things look smaller. Don't DM them. Anyway, bring them in so the jury can actually see them. Sometimes when you have things in trial, you don't know how big it's going to be or small it's going to be until you see the physical evidence. Photos can be deceptive when there's no scale.
Your Honor, may I approach the witness who's been previously marked for identification as states B?
Looks like a baseball bat.
You may.
General size and shape of a baseball bat. A thin baseball bat.
Who's been marked for identification as states B?
But not one of those
Take a
like
look at
shorty
this
little
item.
bats. Like a bigger baseball bat. Look at how she's verifying her initials everywhere.
Do you recognize this item?
Yes, I do. This is the wooden baseball bat I collected from the living room.
Does this item have your name on it?
Yes, it has my name on the Orange County Sheriff's Office evidence label that I filled out, as well as my initials on the evidence seal.
And it also has your initials and your agency case number as well.
Yes, it does.
Ma'am, can you open states B and look at the contents of it to yourself without displaying it to the court?
Yes.
Right. And then they will mark it, and then it will be admitted. And while they're doing that, I will take the moment to answer questions as she is carefully unwrapping evidence. I have an idea we're going to be doing that for the rest of the day. Stephen said, evidence not in solo cups, haphazardly astrew in a paper bag. How bizarre. I am shooketh. I know. It was like rules didn't exist. It's so interesting going jurisdiction to jurisdiction and seeing how different things are done, isn't it? It is always interesting. All right, I'm gonna move myself a little bit just so the super chats can super chat. Trophy Wife said, I suspect she hit him before he got in the suitcase. I don't know. And I don't know if we will know, but we will see. So, Yellow Pill said, who knew Florida would be the place where we have a normal trial? Making me proud. Not a Publix bag in sight, right? It's just, Florida's just like, hey, we're not bothered. We survive hurricanes. The alligators or crocodiles or whichever one pop up in our pools, and we're all just incredibly chill about it. So they're like, we're just going to be chill. This
What is contained within
goes to
state
organization
The
and
wooden
preparation.
baseball bat.
And is that bat in the same or substantially the same condition as it was at the time that you collected it on February 24, 2020?
Yes, it is.
Looks the same.
Your Honor, at this time, I'd like to move what's previously been
Move
marked
it into
for
evidence.
identification as states B into evidence.
And then it can be
Any
published.
objection?
No objection.
What was pre-marked as B will be received into evidence as states 10 without objection.
Luna said, EDB, please shout out my niece Vivian. She auditioned and made it to Pasadena City College Honors Band. Congratulations. She's going to march in the Rose Parade as a sophomore in high school. I'm so proud. That is such a great moment, Luna. It is such a cool thing to see. Honors Band is truly a tremendous honor, and the Rose Parade is unlike anything else. So congratulations, and I hope she enjoys marching band for many years to come. It's great. I loved getting to see my friends do honors
Your Honor,
band.
request permission to
For me, it
publish-
always
You may.
conflicted with water polo. Decisions that we make. Katie said this is actually very straightforward, which is rare. Yep, it is. Jamie said, can you imagine how much less smoothly the process would go if Sarah Boone were still pro se? Yeah, oh yeah, Jamie. It would not be this. It would not be this at all. There's the wooden baseball bat. It is a wooden baseball bat. However, it's not one of those shorty bats. And in a picture, you can't always tell. So there you go. Sweet Pea said this is what it looks like to preserve evidence. Bravo.
You also
Exactly.
had an occasion to collect a suitcase as
That's
well.
what's in the big box.
Yes, I did.
Prior to placing the suitcase into evidence, did you process it?
I took measurements of the suitcase.
What are the measurements of the suitcase?
I'm very interested in this.
It was 28 inches in length, 20 inches wide, and 8 7/8 inches deep.
Your Honor, at this time, may the witness step down from the stand
And get the suitcase?
approach the clerk's area.
Yes.
In the well. Like she needs to go. Can she go collect the suitcase? Can't you just wheel it to her, counsel? Box is awkwardly shaped.
Ma'am, I'm showing you.
Rachel, good to see you.
what's
Thank
been
you.
Marked for identification as states A.
Well, we were right.
You recognize
It was in
this
fact the
item.
suitcase.
Tell us, what is
What we thought
this
it would be.
item?
This is the suitcase I collected from the living room.
And how is it that you know that this is a suitcase you collected from the living room?
It has the Orange County Sheriff's Office evidence label that I labeled with the item description. It also contains my name and the agency case number, and my initials are also on the evidence sheet.
Ma'am, at this time, could you open states A and look at the contents of it to yourself?
All right, she's gonna be opening the suitcase. I'm gonna try to answer some questions. It does look like she changed her gloves. She's been great. And this is presented very smoothly. No complaints on that. Green Mama Lulu said the witnesses and evidence are being presented in a timeline sequence. That's why the questions are so pointed and specific. Yes, and I would just offer that it also goes to their preparation, because you don't ask witnesses a bunch of random shit if you know what witnesses are going to answer those questions. Again, I think my analogy was good
What is inside of states A?
of going to the grocery store with a list versus without.
And does it appear to be
It's smoother when you're
the same or
prepared.
substantially the same condition as the time that you collected it and placed it into evidence?
Yes.
Your Honor, at this time, I'd like to move what's been marked for identification as states A into evidence.
Any objections?
No objection.
What was pre-marked as A will be received into evidence without objection as states 11.
All right, the suitcase is in
Your Honor, at
evidence as
this time,
states
I
11.
ask for permission to publish states A to the jury.
You may.
It's now states 11. And that is the suitcase hidden
Can you open the inside of it?
behind the podium, but I'm sure the jury can see it. It is not a large suitcase at all. And they're asking her if she can open it. It's interesting that it took her a minute because there's no pull on it, but it is so small. Her struggling to open it in court, I think, is just genuine because there's no zipper pulls. And she's showing it to the jury. A lot of you are saying it's much smaller than you imagined. Mm-hmm.
How easy is it to operate the zipper that closes the suitcase?
It was a little difficult.
When we get to the
I have
autopsy,
no additional questions
we will hear more
at this
about the height and weight of the victim.
Any cross-examination?
At the time of death, he was like 103 pounds.
Good afternoon.
Good afternoon.
And now to cross.
Are you also referred to as a medical examiner investigator as opposed to just crime scene investigator?
No, that is not my title.
Do you do reports that the medical examiner necessarily relies upon?
Not me.
The process of doing the autopsy and additional investigations.
You would have to ask them.
Who makes the decision at the scene as to what
Not my job.
items will be photographed and what items will be taken into custody, what items will necessarily be tested or analyzed?
That's a collaborative effort between the crime scene investigator and the lead detective while on scene.
Again, that a little up.
Yourself and who was the lead detective?
The lead detective was Chelsea Kepsel.
Now, you authored a report in this matter, did you not?
Yes.
And that report was utilized, if you in fact know, by the medical examiner in developing her autopsy report, was it not?
I don't know.
I do not know.
In your report, did you?
Counsel, why are you asking her a bunch of shit that is very obviously not her job? Did the medical examiner rely on your report? Is she the medical examiner? Ask the medical examiner. What?
Advise the medical or whomever might read your report that in fact the body had been removed from the suitcase by first offenders or first responders?
No, I don't believe so.
And we know that you have capacity to do DNA analysis, correct?
No, we process DNA or collect
DNA.
swabs for DNA, and then that's submitted to the Florida Department of Law Enforcement for conventional DNA analysis.
You did that with a sample from the inside of Sarah Boone's mouth.
Her buccal swabs were submitted to the FDLE.
And who made that decision?
The detective and I.
Who made the decision not to bother to do a DNA analysis on the blood from the items within the suitcase or the suitcase itself?
That was a discussion between the detective and I.
And you chose not to do that?
No, we did not.
You assumed that the blood inside the suitcase belonged to Jorge Torres, correct?
There was blood observed in the suitcase.
But you don't know who that belonged to because you didn't bother to analyze it or have it analyzed, correct?
Is this your
The
defense?
blood was not tested.
Now, State's Exhibit B.
Sir? They showed all the photos of Sarah Boone, and she has no injuries on her. So where else would it come from? Because Sarah Boone, in all of her conversations with law enforcement, said that George was bleeding. George was bleeding.
The back.
Okay, so
You took that into evidence. Was that again a collaborative decision by yourself and the lead detective?
she's like, why
Yes.
are you mad about that?
And what efforts did you make to have the bat analyzed, given the fact that it was apparently evidence?
It was just collected as evidence from the scene.
Did you advise either the lead detective or anybody else involved with this investigation that there may be matters that could be analyzed when analyzing the bat that would help or assist in the investigation of this matter?
No.
It's my job to do the documentation and the collection of evidence.
Well, you said it was a collaborative effort between yourself and the lead detective, so did you participate in that decision?
She does the documenting.
We chose to collect the bat and put it into evidence.
And so there was a fiber analysis done on the bat to determine whether or not it was used to strike Jorge Torres when he was in the suitcase, was there not?
Pardon?
In fact, there was not, was there? There was no effort to analyze the bat.
He's so aggressive, and she's like, what?
Have an opportunity to answer the question.
She's like, what?
Just
Are,
hang on.
what?
Please,
Can you repeat the question?
She's trying to have a
if I
moment.
can remember it, I will. Do you know
You're-
that there
this
was
is not
any
your
effort
moment, sir.
made in this particular investigation, the investigation of Sarah Boone, to analyze the bat for fibers?
No, there was not.
And why was that not done?
It was not done.
You indicated that you had some interaction with Ms. Boone, is that correct?
I collected her buccal swabs.
Did you speak with her?
In collecting her buccal swabs, yes.
Did you speak to any other witnesses?
No.
Did you make any determination of other matters that might be of import or evidentiary value when you were going through the house and taking photographs and documenting the interior of the townhouse?
You'll have to be more specific.
Well, how many pictures of the child's bedroom did
What?
you see?
Here today,
Yes, ma'am.
we saw the entrance to the bedroom as well as a photograph of the interior of the bedroom.
So two.
What was the evidentiary value of that?
That's a legal
It's my
conclusion.
job to photograph and document while on scene, so the rooms in the upstairs were photographed and documented.
Point
Did you
speaks.
photograph
He's calling for a legal conclusion.
holes in the wall, possibly made by the victim?
That's compound.
I don't recall photographing holes in the wall, no.
Did
you
you
see
take
any?
photographs of items within the house or throughout the house that may have depicted incidents of prior violence?
How would you know that?
You'll have to be more specific.
How about bloody pillowcases? Did you make any effort to collect and analyze pillowcases of the rooms that you were photographing?
Did you see any?
No.
Who made, you have significant experience with zippers?
I use zippers regularly, yes.
Enough to have an opinion as to whether or not a zipper is stuck or not.
It's
What?
Sorry?
You testified on direct that the zipper was a little tight.
She said it was a little
Just
difficult.
that it was difficult without the zipper pulls to use the zipper.
And that was your opinion.
No, that was her experience.
Yes, from opening the suitcase here
She
today.
tried to unzip it, and it was hard.
You only tested it today?
She didn't
Pardon?
test
You
it.
only today have for the first time tested the ability to pull open the zipper on the suitcase?
No, I'm saying it was difficult today.
To do.
A redirect examination.
Yes, Your Honor.
I use zippers regularly.
In this
We-
case,
We watched her. I don't know, maybe defense wasn't watching her. We watched her try to open the suitcase, and it was a little difficult to open because there were no zipper pulls. So that's your opinion? No, that was just my experience with trying to open the fucking thing.
you documented the entirety of the house as you saw it.
Yes.
So every room in the house,
They were all taken overall photographs.
walls in the house.
In the overall photographs, yes, they weren't all individually photographed, no.
And you did not document or note any type of holes in the wall or any type of damage to the walls, anything like that?
Not the walls, no.
Is that something
wall, they
that
would have
would
noted it.
have been documented both photographically and also within your report?
Had it existed.
Yes.
Right.
You also, as we've previously seen in the composite,
The defense attorney's like, and you didn't document any holes in the wall that might have indicated passive violence. And she's like, no. And the prosecution's like, if there were holes in the wall, would you document it? She's like, yes. Right. That's because there weren't any.
saw the victim where he was laying in this case, correct?
Yes.
Was the victim, did he have blood on his mouth and on his face?
Yes, he did.
Did he have open wounds on his body?
There was blood coming from his nose and his mouth. There was also some other areas of like defects noted on his body.
You also made contact with the
She's so
defendant
calm.
too as well.
Yes.
Did you note any other wounds or cuts or anything else that was not documented that you haven't testified to?
No.
So no wounds, nothing on her.
Not that I recall, no.
No further questions.
Anything on
Can
recross?
this witness be released?
Yes, John.
Mr. Owens, can this witness be released?
Judge, we'd like her to be on call.
Subject to recall, ma'am. Thank you.
We want to know more about how regularly you use zippers.
Can the parties approach?
I bet we are at the end of the day. When I'm looking at how much was left of stream, let's see what time he tells the jury to be back on Monday, because I'm...
Members of the jury, thank you so
Yep. We are at the end of the
Members of
day.
the jury, thank you so much for your attention in this matter. It is 4:52. At this time, we're going to go ahead and take our recess for the evening.
Have a good weekend, everybody.
Madam Clerk has letters that I have signed regarding your jury service for you to provide to your employer. Court deputy will provide them to you in the deliberation room.
I need that letter to say, I'm on jury service, bitches. See you in 3 weeks. I don't think that's what the letter says.
Before you are released for the day. I have a similar instruction to read to you that I gave you before the lunch hour. Jurors, you must not conduct any investigation on your
We're going to do a
own.
quick Q&A after this.
This includes reading
And then I've
newspapers,
got to
watching
zoom
television, or
I
using
have
a
some mom
computer,
obligations.
cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case.
Iowa travel nurse.
This
you are
applies
making
whether
me
you are in the
cackle.
courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort
Your Honor, the
with
internet
friends,
is
family
everywhere.
members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face to face,
Yes, the jury can use
you must
zippers,
not
but
talk
they
about
can't
this case
apprise
by
if it's
using an
difficult or
electronic
easy
device.
to use those zippers.
You must not use phones,
Zippers.
computers, or other electronic devices to communicate.
It's been a long day.
Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I'm going to release you back to the deliberation room for you to
To the
receive
wild.
the paperwork for your employer, and we will see you at 9 a.m. this coming Monday, October 21st. And I thank you for your sacrifice and your service.
This jury has it good, Your Honor. The state got through 10 witnesses and opening today. It's just... This jury has it sweet. They should see some of the things we've watched, Your Honor. You have run this courtroom like a delightful, tight ship. It's just all zipped up. Yeah, we're not getting away from the zipper thing, though, I don't think. I think we're there.
You all may be seated. Thank you. State, anything else we need to discuss?
Not from the state.
Defense. All right, thank you all very much. We will see you at 9 a.m. Monday, October 21. We're off the record.
Good day one, everybody. Well done. Well done. Amazing day one. Y'all, law nerds, we did it. End of day one of Sarah Boone, the trial that honestly I thought would never start. Ever. I got asked a lot, Emily, are you covering this case? I'm like, I'll cover it when it goes to trial. They're like, when are you covering it? I'm like, I mean, maybe never. I'll cover it when it goes to trial. Because if I had started covering it when y'all started asking, it was going to be like a year and a half ago. And I was like, oh, no, I don't know if I can. She writes a lot of letters to the court. I don't know if I can get down for all that. But she seems very happy with her lawyers. The case seems to be moving smoothly with her lawyers. And we're just, parachuting right through day one. Okay, we're going to have lots of internal jokes with today. Let's see if we can get a little end of the day summary. And then I am going to do just a few questions and we have got to scoot because I have some mom obligations this evening. At the end of day one of Florida versus Sarah Boone, the state got through 10 witnesses, including lots of their body cam evidence, the defendant's ex-husband, Brian Boone, and the crime scene investigator that recovered physical evidence from the crime scene, including the megabytes? No, that's digital. The megapints or magnums of wine and a baseball bat and the suitcase in this case, which I think the resounding opinion in the chat is that it seemed much smaller when it was brought into the courtroom than it was perceived to be on the video that people have seen from this case. And even in photos, it just seemed smaller when it was there in the courtroom. And so today we got through a lot of the foundational evidence and moved through incredibly quickly. Very few objections, maybe only one or two. Lots of evidence moved in, the crime scene photos, the physical evidence. I already said the body cam footage. So I imagine as we get into next week, we are going to see very early on the coroner and other evidence. And then we will get into the lead investigator and all of Sarah Boone's other interviews. But this case, I don't think is going to take nearly as long as the 3 weeks that the jury are qualified for. In opening statements, the defense did say they expected the jury would hear from Sarah Boone next week. So I think we will be through the state's case in just a handful more days because they are moving through quickly. And when you have a clear picture of where your case is going and what the evidence is, there's not much more to say. They need to bring in the cell phone videos from Sarah's cell phone, her digital evidence, which will be probably with their lead investigator or the technician that downloaded it, her interview, and that's really not too much more. It's just a very clearly presented case at this point at the end of day one. And it's refreshing to see. The crime scene investigator had like crime scene tape and like a whole chain of command. It was really nice to see everything running smoothly without any hyperbole or fuckery. 10 out of 10, everyone running this case. And I think some of that reflects on the judge as well. So with that, let's get to a few questions and then we're going to go have a Friday. Thank you everyone today who gifted memberships. Thank you everyone who super chatted. I know I will not be able to get to all of them, but thank you very much. I appreciate it. Neen Mock asked, okay, I have to ask, is closing arguments, will someone be swinging the bat? God, I hope not. I think it would be a little bit crass in this case. I mean, then again, I thought it was crass when Poot was pointing the weapons all over the courtroom, including at the prosecution table during the Murdaugh trial. So I hope not. I think that would be over the top. I think all they need is to show the suitcase again, and they've shown the video. Patera in the chat said how long the trial could take, a week and a half, maybe. I don't know how many more witnesses the state has, but a week and a half, maybe. It's gonna be shorter. I think. The state got through quite a lot today. Just quite a lot today. Liz said, I wish you were covering Young Thug. I have touched in on that case off and on the Emily show that goes out on the audio feeds on Wednesday and up on this channel on Wednesdays. I have not checked back in recently because so much legally has happened. It's a ton to catch up on. I could not stream that case day to day. That case is going to go till next year. There's not a chance. There's not a chance that I could. So I will touch back in because a lot legally has happened, but I'm going to wait until I have a chance to catch up because we've got some other cases I need to catch up on before then. So let me get to a few more of our questions, comments. Anne said, "Don't you miss every witness describing the weather and what, if any, height of various pieces of furniture it was?" Lally didn't have to ask all those questions. He just did ask all those questions. Eloy said, "Swoop Loops, the official Law Nerd cereal." Yes, the Swoop Loops are doing the things, but I'm glad this trial just got started. I really, really am. Alley Cat said, "I'm so excited that you're covering this real time. You're the only one I wanted to watch this trial with." Well, thank you, Alley Cat. Thank you for teaching me law in a way I understand. That is the goal. So that's what I hope to do. Chantel said, "New ink and a new trial. Best day off ever. Thanks for body doubling with me today." Congratulations on the new ink, and I am glad you're spending your birthday with us too. Zeb asked a great question in the chat, and I saved it till we had a chance to talk about it. Zeb said, "Emily, what is improper impeachment? I'm behind. Sorry if it was already answered." Zeb, there's always time to talk about impeachment and improper impeachment. I'm going to try to summarize the rules of evidence and hopefully make it succinct. You can impeach a witness with a prior inconsistent statement, for example. So if the witness comes in and testifies and says, "No, this happened on Thursday, it was nighttime and it was raining," and previously they had told police it was Tuesday, it was daytime and it was sunny, you can impeach them by saying, "Today you're in court saying it was Thursday, it was nighttime and it was raining. But when you talk to law enforcement, it was daylight and it was Tuesday and it was nice weather. So which is it? Were you lying then or are you lying now?" It's a terrible analogy or a terrible example on the spot, but it is an impeachment of you said this thing and this directly impeaches it. But if they don't ask essentially the same question to elicit the same answer, you can't impeach them with something that they didn't say. And so there is room when somebody's trying to impeach a witness that it is not the proper impeachment because it doesn't contradict what they said, or the question was vague or unclear, so you can't impeach them because you didn't ask the question well. So improper impeachment is an objection saying, "Your Honor, they can't get into this with the witness because they haven't really laid the foundation to impeach in that way, or it's not contradictory." So there's room for that. I see some of you starting to comment that the stream's a little out of sync. That can absolutely happen as the streams get onwards into the 8 hours range we have found. Rolling Along said the New York Times had an article on the best restaurants in Nashville. I'll take a look. Hopefully it's not behind a paywall. Can't believe this trial is finally starting. Rexy55, neither can I. Glad to see so many of you here with the snackies. I know we had a lovely chat in the Law Nerd Lounge about that. If you're interested in the Law Nerd Lounge, it is a private area of our app that is members only over at lawnerdlounge.com. You can join the conversation over there, and we are happy to have you if that's something that you want to do. So with all of that, I know I didn't get to all the super chats, but I do have band mom duty. So I will see you all on Monday. I will let you know what time I'll be starting, probably around the same time today, either 8:30 or 8:45 is when I will be starting. Laura, I see your comment. I'm going to try to find it real quick because I see it. And it is, let me see. I will try. There it is. Okay. Laura, thank you for pinging it. I see it. Laura said, "Is the defense giving away their strategy with the battered wife syndrome book at the defense table?" No, they've already disclosed their strategy. They talked about it in opening. The prosecution talked about it in opening. It is known that that is the direction they're going. I think it is a way that they are maybe reminding the jury that that is the direction they're going because it's just sitting there at counsel table where the jury can see it. So I don't think it's giving anything away. I think if anything, it is a reminder perhaps to the jury that that is the direction that they're going. So you are welcome. I don't know how that's going to go for them, given Sarah Boone's statement to police. Her statements to police, she seemed very concerned about the victim's family knowing that he was deceased. She seemed very concerned about making sure that this was not intentional in any way. And she seemed very truthful, saying, I forgot he was in the suitcase. I don't know, you guys. We're going to listen to her level of intoxication on those audios. She told others she wanted to kind of scare him a little bit. She told law enforcement on that body cam that she wanted to like mess with him or freak him out a little bit. And then she forgot. And she was like, oh my God, I forgot. She kept saying, oh my God, I forgot. She might have. Or she might have said, he'll be fine in the morning and gone to bed. I don't know. But we'll find out. So with that, you guys, I have to zoom. We will have lots of time together on Monday. I don't have any meetings Monday, so we will have a normal, not in big into lunch break. And with all of that, Law Nerds, thank you for being here. Thank you for being Law Nerds. I love streaming trial with you. Thank you for joining me on the gavel to gavel coverage, possibly our last for 2024. So thanks for being here. Thanks for being a Law Nerd. Have a restful weekend. Get all your shit done, because we got a lot to do on Monday. We're going to be back in trial. Have a good one. Hey, it's supposed to play the outro there. Hold on. Now, Silent Bob. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.